All right, so this is here on your motion. It's filed February 6th. I did have a chance to go through all of the documentation. So,
Mr. Honor received the final GAL report that was filed on the 29th.
that's correct.
Okay, correct. For the record, Megan Gilmore on behalf of the respondent and moving party, namely Travis Bryant. This is before the court on my client's motion to modify the temporary orders and adopt the guardian ad litem's recommendation. For the record, the guardian ad litem has filed two reports, an interim report in January 29th, as well as a final report on February 29th. The guardian ad litem is now recommending that it is in the best interest of the child to live with my client. The report confirms my client's prior statements that he's made throughout this case regarding mother prioritizing for romantic relationships, being away from the home for long periods of time, and the deterioration of the child and the mother's relationship. Despite being under the microscope of the court case and investigation, mother continues to live outside of the family home despite the temporary orders and leaves this child to fend for himself or be cared for by my client outside of the residential time that's awarded to him. This is consistent with the behavior that was exhibited by wife throughout the marriage and further confirms my client's role as primary parent, again, prior to separation and now throughout this case. Wife priorities are so skewed that she didn't exercise visitation up to even the last weekend before the report was filed and spent the time out of town with her boyfriend.
And again, this is part of the problem. We don't object to any of that comes in. We didn't have a chance to respond to that. My client's declaration has been in since February 13th. We've got two different GAL reports that were submitted to that. Anything that came in after the date of my client's response, I would object to.
Well, hold just a second. Your client's response was, just one sec. When was your client's response filed? The date on that?
February 13th. And we certainly have a response to last weekend if we need it. Again, that was produced in the GAL's most recent submission, which I think we got a copy of that on Friday.
Well, do you want time to respond to that? I mean, the GAL report is what I'm looking at.
Go forward today. I'll leave that up to your honor. I mean, I've got
I'm
quite a few issues to go through with kind of the processing of this and some of the comments in the GAL recommendation. I'll leave that up to you. If you want us to go through the most recent GAL report, I can certainly enter a response to that. But at this point, we're getting pretty close to what we would do and introduce testimony at trial, which is part of my concern with, of course, having these GAL reviews and asking for a change of custody on very limited scope of information from a GAL, which is a recommendation. It's certainly not an order of the court. So if you'd like a written response to that, I'm happy to give that. But again, we need time to prepare that.
Counsel, how do you want to proceed? I mean, I've got the final GAL report, which is just what I was kind of like reviewed mainly for this hearing. So
I have to defer the court. I mean, it's the same information that was provided in the interim report. There was some sort of argument within the responsive materials that this should be further delayed for the final report. We now have the final report. If the court wants to give her the opportunity to provide a written response, I simply don't think that there's a need for that. And again, the allegations are the same. She simply hasn't been at the home, hasn't been exercising visitation, and she's frankly responded to that in her responsive materials.
well, the Guardian report that was filed in about a month ago, that was a pretty limited report compared to the final. There's quite a bit more in it. Recommendation isn't significantly different, I think, but it's more detailed.
I think the priority is to consider the recommendations of the final report. So if the court's inclined to that she needs the opportunity to respond to that, then I would ask for a set over because I think it's vital to review.
I think I'd be inclined to do that because I've read that one. That's kind of what's in my head at this point. I probably need to have a response to that.
And there's, I would state that this is going to be part of my concern expressed today. We've got the GAL appointment order that says it's limited in scope. Obviously, as the court is well aware, a GAL order is pertaining to the best interest of the child. I think we all get that. As an investigator, they are confined to that premise. We have a GAL report here, which almost appears as.
Just one second. We're getting some feedback from somebody.
So if you look specifically at that 1117 GAL appointment order, it's pretty basic on its face. What we have here is we've got a party, Mr. Bryant in this case, who files a motion after the interim report becomes published. As I've expressed my concern, we file our response to the motion. Again, my basic paramount concern to this is a GAL report is a recommendation. It's nothing more. In and of itself, that is not adequate cause to change anything. And if you look at the recommendations here, it goes well beyond what Ms. Height was appointed to do, which was investigate interests related to the child. She goes on page 14 to go so far, and this is where it becomes advocating on one party's behalf. She goes so far as to state that the mother, this is a recommendation, vacate the home in 45 days. Consideration be given for the mother using a travel trailer currently in Travis's possession, which again, looking at the context, this is odd. She's referring to my client as mother, referring to Mr. Bryant as Travis, first name basis, in Travis's possession until more permanent housing can be secured. She goes so far then as to say Travis pay for any hookup or space rental fees for 2 months if the trailer operation is chosen. I am 100% confident that that far exceeds what her appointment order was back in November. She's now advocating on behalf of one party versus the other. I think that's grossly in error. I think it's grossly inappropriate. I think that's kind of the basis for where we're at with this. I think that far exceeds what she was appointed to do. She's now in the advocate role for one party over the other. She's also in place of the court saying, here's what needs to happen, acting as some kind of an arbiter or judge. Significant issue. This is the stuff we got to go through. That
I mean, we can, if you want time to respond to the report, I mean, I can do that. If you want to do that.
It's up to you. I can go forward today. If you want more time for my client to respond to this in writing, I can do it. I just think it exceeds it.
Okay, well, I have a motion to adopt the recommendation. That's what's
the
in
first
front of me.
recommendation, which was back in January. That's the interim recommendation. This is the final recommendation that we received 2 days ago.
Okay.
2 court days ago. Which directly relates to the relief requested in the motion that again was after the first recommendation, the first interim report. Again, we have no mention of the house. We have no mention of recommendations for Mr. Bryant paying for hookup or space fees, which again far exceeds the appointment order, which coincides with what he asked for in the motion. Almost like he's filing 2 distinct responses, which again is the concern that he's got 2 advocates on his behalf right now, one being Ms. Gilmore, one apparently being Ms. Hyde.
I don't know if the court wants me to respond to the alleged advocacy or conflict issue with the guardian ad litem. I don't think there's any basis to it. Mother simply just doesn't like the recommendation. We are asking the court to adopt the guardian ad litem recommendation, which includes her having Monday through Wednesday. I think that this is just a simple, like I said, a delay tactic. The court has the report, has the authority to adopt those recommendations based on my client's motion to modify the temporary order. Wife had the ability to respond, and we cannot set this over for her to respond to the new information contained within the guardian ad litem report. If the court wants us to file an additional motion adopting the new report, we're just causing further delay of 3 weeks while this child's mental health is deteriorating. I don't think ultimately that's in the best interest of the child. And again, I think that due process has been provided to mother to respond.
I don't want to delay. I want to go forward today. I'm more than prepared to go forward today, but there's some very significant procedural issues with this, as well as some oversteps of the GAL. That's my point.
Okay, well, the motion that was filed that was set over had to do with the 129 report, which, I mean, it's different than the current report.
It basically comes down to a legal analysis. Is there threshold showing that there's a change in circumstance? Generically say, well, the child's mental health is deteriorating, and that's not anywhere contained in either GAL report.
Getting into argument, we're either setting it over or.
Okay, well, okay. Do you want to hear it today based on what we have? You want me to set it over? I'd be happy to set it over if you want to file some.
No, let's
additional
move forward today. I'm just raising that, just lodging that objection, just to be clear.
Okay. Well, counsel, if you want to go ahead at this point, I'll listen to your arguments and we'll make a decision.
Thank you, Your Honor. And again, I would ask the courts to review the guardian ad litem report. I believe that it is accurate and it does reflect the situation of the parties after a thorough investigation. Within that report, the guardian ad litem cites no safety concerns on the part of my client and again recommends my client to be the primary parent. Despite repeatedly maligning my client's character throughout this case, wife has created no nexus between my client's alleged drinking, which she's repeated over and over, and any safety concerns regarding this child. To the contrary, wife acknowledges my client's role as primary parent and the fact that she doesn't have concerns about my client's alleged drinking by the simple fact that she has allowed my client or relied on my client to exercise all, if not a majority, of the parenting duties and responsibilities for this child, again, during the marriage and that separation. At the time of the temporary orders, we provided calendars, we provided doctor's records, we provided communications and information with teachers. All of that supported the fact that my client has been historical primary parent. Even after filing this recent motion, wife contacted my client's friend, and we've submitted this in an exhibit where she's asking to simply have a 50-50 parenting plan in this case, while claiming my client was in fact attacking her character. So as we stand before the court, I believe that wife legitimately believes a 50-50 parenting plan is in the best interest of the child and simply wants to maintain the current visitation schedule that she frankly is not exercising simply based on the financial resources that are provided to her by being a primary parent. My client has done everything possible to prove that he does not have a substance abuse issue. He's taken now 2 evaluations, one with input of numerous sources, including respondent in this case, which all confirm he doesn't have a problem with alcohol or substance abuse. He provided drug testing at the beginning of this case and is willing to, and submits to this in declaration, is willing to continue to do drug testing thereafter to ensure a residential schedule that's in the best interest of the child. We haven't received any requests for drug testing on the part of mother, and there's nothing in the court order requiring so. But again, we are happy to voluntarily provide this. The incident on Father's Day was now almost a year ago and has been fully fleshed out at prior hearings as well as investigated by the guardian ad litem. My client wasn't drinking. My client didn't follow mother after the dispute that happened at the house. My client remained with the child. The child wasn't present for this incident, and my client didn't assault mother. The parties continued to live together for almost 7 months after this June incident in 2023. So again, her claim that the visitation schedule should be drastically modified because of this June incident simply doesn't hold water by the fact that, again, they lived together for 7 months, and my client, again, performed a majority of those duties prior to filing this case. Wife brings new allegations from as far back as 2013 to avoid the simple fact that she hasn't been there for this child in this case. My client never put water in her gas tank in 2013. He surely didn't ever attempt to self-harm. I'm confident that if this was true, mother would have presented this in other declarations throughout this case. More importantly, I think the most importantly, the child of this case has repeatedly been interviewed by the guardian ad litem and has reported that he's never seen his father intoxicated and has never had concerns about his father's ability to parent. The child in this case wants to live with my client because of the historical relationship of him and his father, the historical roles of him being the primary parent, and the problems that he's having with his mother ongoing, particularly I would say that have escalated since the temporary orders were entered. Wife's 18-year-old daughter, who has lived with these parties for all of her life, also confirms that she's never seen my client intoxicated. Wife sought to have a majority of the time with this child of this action, but now leaves him alone. Wife, again, when she is at the residence, the guardian ad litem confirms that they have ongoing conflict. The child and her have ongoing conflict on a regular basis. Wife has no evidence to support her allegation that my client is involving the children in conflict. He adamantly denies that. To the contrary, which isn't denied by mother, she sat down the party's 18-year-old daughter and went over the pleadings of this case. So she, in fact, is the one involving the children in conflict ongoing. In summary, we are asking the court to adopt the guardian ad litem's recommendations, name my client primary parent, provide wife visitation every Monday and Wednesday of every week. We believe, again, that that's in the best interest of the child, and ultimately, as the court's aware, when entering a parenting plan, we must look at what's in the best interest of the child, not necessarily what's in the best interest of the parents in this case, which again, there's ongoing conflict, obviously. This is new to me, the allegation that Ms. Height has somehow been inappropriate. Again, I don't need to defend Ms. Height. She can speak for herself. She's not advocating for my client in any way. I didn't see any sort of impressions. If anything, I think that she really thoroughly investigated and questioned both parties throughout this case and pushed for a parenting plan that's in the best interest of the child. I don't think she's advocating for my client. I think the mother's frustrated that the GAL is advocating for the child. And unfortunately for her, that has resulted in a parenting plan which is inconsistent with her petition. So we ask the court to, again, adopt the recommendations. That can be the recommendations on January 29th. I frankly think that's not to the advantage of mother, because in the final report that was recently filed, Ms. Hyde is recommending the mother have an additional weekend. But if the court wants to go off of the interim report, I think that the court has the ability to do so. And we are asking, based on their motion, to provide her Monday through Wednesday visitation and name my client primary parent. I think that all of the financial aspects can kind of be lined out based on what the recommendation is or the court's ruling is regarding the parenting plan. We are asking that my client is allowed to move back into the residence. He's maintained his position throughout the case, and it's not denied by wife that she didn't want the home on a final basis. I don't believe that the guardian ad litem is necessarily stepping outside of her realm of authority within the order. Who is allocated the house is really addressing who's primary parent and really looking in the best interest of the child on where he's going to be residing. If he's going to be residing with my client, then he should be in the home. And I don't necessarily think that the court needs to take authority, obviously, on a recommendation of guardian ad litem regarding property or expenses. But I really think that, again, I can't speak to Ms. Hyde's mindset, but I think that it is within the realm of the broad authority that the order that does provide that was entered by agreement in November. Just simply stating that this child should remain at the location that he's lived at and that my client should return to that residence. Again, I think that just on the property and of things, which was subject to my motion, I don't think it's denied by anyone that the property has continued to deteriorate while in wife's possession on a temporary basis. She simply has historically never been involved in maintaining this farm, ranch, whatever you'd like to call it.
There being any allegations that the property is deteriorating, I might have skimmed that over.
I don't think I have any declaration along those lines that I read.
Simply, we're asking the court to adopt the recommendations of the guardian ad litem, provide mother visitation Monday, Wednesday, and allow my client to return to the home and live in the home. We are asking for we asked for 30 days within our motion. I'll defer to the court on that. And I think on presentation or a subsequent hearing, we can determine support based on what the court does with the residential schedule.
Mr. Zandy.
And I appreciate that, Your Honor. As court sworn to represent the non-moving party of the petition in this action, namely Ashley Bryant. Now, you have heard a couple of my concerns. This is now the third time we've been in front of a different judge in this case. Commissioner Harvey heard this matter initially back before the holiday season. Judge Hahn considered a revision motion that was filed a short time thereafter. Both judicial officers concluded and contemplated the fact that the pictures that were filed and submitted back in the fall, the evidence that was presented again, which is a sampling of the case back in the fall and throughout the winter, had concerns about Mr. Bryant's candidness to the court, number one, and also his commentary about his alcohol consumption and the issues potentially on this child right there. So I would start by submitting that. And again, what's the adequate cause? What's the basis to change the existing parenting schedule? And there is none. A simple recommendation by an investigator chosen by this court is not adequate cause. It's not a change in circumstance to either party. It's simply a recommendation based on investigation, again, by a neutral third party. That is not a change in circumstance. Come forward and bring a motion based on an interim report. Again, that was filed over a month ago to suggest that, well, I want everything to change. Same thing that was denied on a temporary basis from Commissioner Carmi, the same thing that was denied on review from Judge Hahn, again, is inappropriate. There is no change in circumstance to my client. There is no change in circumstance to Riker outside of a GAL investigation recommending something and saying, this is an open-ended investigation, more work needs to be done. And this is a case that needs to have testimony, evidence, and trial. And both of these parties are entitled to that. My client is entitled to put up that information on, as is Mr. Bryant, so the court can get a full scope of what is actually happening here. My client, and I'll use Ms. Gilmore's term, frustrated, is frustrated. Again, I think if you look at the timing of this, it's suspect to say the least. And we have an individual who, again, goes into the GAL investigation, puts whatever information was set forth therein. GAL talks to the 12-year-old child, talks to the 18-year-old daughter, and the 18-year-old daughter, again, who's not subject matter of this case and graduates in June, and talks to her boyfriend. Comes back and says, well, based on the information, based on the fact, I'm going to issue a 6-page report, which again is very preliminary. I'm going to continue with the investigation, but I think for an interim period of time, it might make sense to try something different. Let's look at that. Ms. Height suggests that we go every Monday to Wednesday with my client. My client works at Fiber Federal. She has routine hours, which again are Monday through Friday. She's home by 5 o'clock every afternoon, which again was put in motion by these parties years ago, recognizing her role as the primary parent. Never once has anybody said, and again, in neither report, I don't know what you're considering or what the court's thinking on this, but in neither report does it ever dispute the fact that she was the primary parent for both of these children, but Riker is the subject matter here today. Never once does it contemplate that she wasn't the one who took this child to doctor's appointments, to the dentist appointments, and dealt with the schools directly, as dad was working 4 on, 4 off. And that's not to minimize his role. That's just to recognize the fact that she was at home for this child for the first 12 years of his life. As she stated to the court numerous times, as she stated to the GAO, and provided the GAO with significant information from lay witness third parties, recognizing that. We don't see that. We don't see any discussion of that in either report furnished by Ms. Height. What we have is the initial report comes out. And again, 6 pages of not a lot of information, nothing useful. Everybody she talked to was under the age of 19. Nothing from that voices any kind of concern. In fact, she says what? She says Riker is a well-established boy. Riker is intelligent. Riker is mature. Riker is now speaking, but he's 12. He's a 12-year-old child who's telling the GAO, well, yeah, I'd like to spend more time with my dad. But yeah, nothing contrary to mom. The worst that you have in here is they bicker. Well, you've got a 12-year-old and it's not uncommon to bicker with his mother. That's not a big issue. That's not grounds to change the parenting plan and reverse those roles. Ms. Height suggests that the child spend Monday through Wednesday with his mother, given the fact that dad works 4 on, 4 off, 2 nights, 2 days. I think that's 2 days and 2 nights. That leaves the child home alone for a significant period of time, which, if I understand counsel's argument correctly, they're trying to avoid. That does the opposite of that. We also have information in there from Ms. Height, I'll let her address this, that, well, this was kind of suggested by the 12-year-old child. So now we're putting a 12-year-old child in charge of dictating what the schedule is, when this is the very type of behavior we don't like to put children in the middle of this. She's doing that by saying, well, Riker, what would you like the schedule to be? Meanwhile, we have the child who's with dad, who's getting attention from dad for the first time in his life, who dad is telling him specifically, I want to take you clam digging, it's your mom's time, but your mom doesn't need to know, we'll just do it. We have dad who goes out and purchases a truck for the child, and that's all fine and dandy and well, but this is a 12-year-old who's on the drive for 4 more years, says, hey, we'll work on that together. We have dad who literally goes out and buys the child a puppy and says, here you go, even though mom doesn't want you to have that, we've kind of agreed that we're going to lay off on a dog for a while. Here's a gift from dad. We have dad who then is telling the 18-year-old Ellie, and this goes back to the incident back in June on Father's Day, mind you, where he just so happened to stumble across my client while she's at a friend's house and then barge into the home and threaten everybody. There's 911 tapes. I didn't see any discussion in either GAL report about these 911 tapes where he's specifically telling the listener that you effing want to die, you're a dead man. Do you want to get throughout the—
Well, I object. I don't have a 911 tapes presented by the respondent, so I don't know where she's getting these alleged quotes from.
That's the point. It needs to be introduced at the time of trial or introduced to the GAL.
Well, let's not argue anything that's not before the court at this point.
Well, it's on page 2 of her declaration. Nonetheless, if you get all this information, you're going to see that this is something that needs to be addressed at the time of trial where people can testify to that. For the trier of fact, not the GAL, can get a read on the evidence. For the trier of fact, not the GAL can make determinations related to the parenting plan and what's in the best interest of this child. It is not grounds to come in before your honor to use valuable resources of the court to come in and make those allegations, make the request to modify a parenting plan, which by all intents and purposes is working. This child is doing very well. Again, that's according to the GAL, based on a limited scope of information, again, presented from 3 individuals, Riker, his sister, and the sister's boyfriend of all people, who are under the age of 19. So that's where it comes down to. Let's talk a little bit about the criminal history in this. You have information related to this incident in June. You have the police reports. You have information from the GAL. You have information from my client, in which it says he drives in, he storms into the house. We have the 911 call, which again, the GAL has access to, but doesn't comment on. We have all this information to present, where dad comes in on Father's Day, where he should be at home with his child, and instead pursues my client. They've been contemplating divorce by this time. This has been known and in the works for a period of time. Dad has a girlfriend at the time. Nobody talks about that, but that's one of the interesting facts. Although this person is identified in the GAL's report, we don't have any information as to what the GAL gleaned from this individual. Dad now says, well, she's pursuing other relationships when he was doing the exact same thing. Again, that's information that needs to be presented at the time of trial, if in fact it's relevant, which a strong case can be made that it's not. People move on. There's no issue with that. My client disputes the fact that she's not here on weekends. To now come forward and try to introduce based on what's in the most recent GAL report, again, 2 days old, that, well, my client is not in the home and as recently as last weekend. Again, that's completely outside the purview of what the court is doing today, outside the purview of the motion, which again was filed over a month ago. So we're back to that. It was never the design of the court to have a GAL recommendation, or at least that I'm aware of, have a GAL recommendation come forward and that be the basis for somebody to come in and not just make a subtle change here or there to the parenting plan, but blow the entire thing up, not only ask for difference and changes to the parenting plan, but also the finances, who's in the family home, all those different things based on one person's recommendation. That person not being a judge, that person not being a trier of fact. So I think from just a initial basis, that's problematic. If we look at the other issues with that, it's completely surprising to hear the GAL say, well, there hasn't really been any information that proves dad has alcohol or substance abuse issues. If you look back at the pictures that we gave the court a couple of months ago, where dad is in various stages of intoxication throughout the property, some of which where he's laying on the ground in a shed that's unheated in the middle of winter. If you look at the pictures, that's pretty strong information. If you look at the fact that he had a DUI 7 or 8 years ago, I believe, that's a pretty strong indicator that there's alcohol problems. If you look at the letter from his mother, which again, the GAL addresses that in, I think it was her second report, in which she's going on begging and pleading with the guy to please curb your alcohol consumption. If you look at that from the GAL's perspective or the trier of facts perspective, it's pretty easy to see that there's probably some kind of a substance abuse issue related to alcohol. For the GAL to say, well, I really didn't see any strong indicators that are substance abuse issues based on a one-sided report that he gave a provider months ago. Again, that needs to be explored at the time of trial because there's very strong evidence that we don't typically see at this stage of litigation, suggesting that this person has the magnitude of problem that he has. There's been other law enforcement contacts. Again, we don't see really anything in the GAL report about those other than, well, I don't really know who's telling the truth. It looks like mom's lying, but dad hasn't been entirely forthright either. Look at his own declaration to you. He says back in the initial motion and declaration filed several weeks ago, GAL didn't find any problems and she looked really hard. He doesn't provide her the letter from his own mother that he's had in an email for over a year. He doesn't provide information from the DUI. He doesn't provide information or any kind of rebuttal to these pictures, as opposed to he has his lawyer say, well, that could have really been from anything. Again, who is telling the truth and who's not? That's for you to decide, and you don't have enough information at this point to gauge that. This has to have testimony. This has to have evidence. You have to look the witnesses in the eyes to see who is telling the truth and who is not. Regardless of whether he poured gas or water or sugar or anything else into one of my client's vehicle at the time, what we do know and what we all agree to is there was a police contact. And in that police contact, what's he say? Well, I don't know. I'm not really pouring water into it. I'm not exactly pouring water into her gas tank. Again, that's problematic. If you have the police call repeatedly like Mr. Bryant has, that's a sign of a bigger problem. And to suggest that the kids aren't impacted by this and that Riker's not impacted because he hasn't seen his father drunk, again, I think is missing the point on this. This is why we need trial. Basically, what Mr. Bryant's asking you to do is to come on very short notice, piggyback the initial report that we did have the opportunity, all 6 pages of it, mind you, piggyback that recommendation with now the one that was just submitted 2 days ago, which gives far more information, which again far exceeds the scope of a GAL investigator by recommending what the court does with the house and finances and everything else. I don't know how to say this. Nobody respects Ms. Height more than I do. I think she's an excellent GAL. I absolutely think she missed the mark on this one. I absolutely think she's overstepped what is her role in this process to the order of appointment back in November. And I think we're now at a point where everybody's trying to double down and protect themselves and give you a little bit more information as though this is the time of trial, and it's not. We're not there. We have to exchange discovery. We have to get more information. We have to have witnesses testify like they normally do. And to do that in a 20-minute docket on a temporary basis is not appropriate. And there's not adequate cause. And again, it comes back to the fact and the question, is a GAL recommendation in and of itself, 6 pages at that on an interim basis, grounds for modification? This court has consistently held that answer to be no. So here we are. That's our position. My client has given you the information and her issues with contained in her declaration. I think it's highly persuasive. I think this case absolutely needs to go to trial, as opposed to piggybacking GAL recommendations with what Mr. Bryant wants and referred to throughout the report as Travis, again, in the GAL findings and recommendation. there needs to be a little bit of a testimony here. There needs to be further information. Now is not the time to make major changes to this, especially when you have dad who works a 4-on, 4-off rotating shift. And the suggestion is to keep the child with mom Monday through Wednesday, regardless of that schedule, which is going to leave him at home upwards of 2 nights by himself every week, especially when the older child, Ellie, graduates in June. Basically, by replacing my client from the home, you're replacing Ellie as well. And Ellie graduates again in a few short months. This case hopefully will resolve. I don't know that it will. But again, we need to have some kind of testimony to the fact of what the issues are, what people know. And it concerns me that my client gave upwards of 10 to 12 different correspondences and letters on her behalf, refuting much of what is in the report, that there's no comment on those. These people need to testify. These people have direct knowledge. We don't have that in either GAO or report, again, that were filed and ironically submitted only a few weeks apart from each other. And ironically only submitted the final report on the eve of this hearing after my client does a pretty thorough job debunking many of what we view are inaccuracies contained throughout that report. That's where we are. Moving forward, I am going to object again on the reply responses that we got from Mr. Bryant. He gave us a 4-page declaration with the font seems extremely small. We have a declaration of another 2 or 3 pages from his mother. I think Rule 88 is quite clear that you're entitled to 4 pages in total on a reply basis, and he's far exceeded that. How the court wants to go through that, again, up to your honor's discretion, what you think is appropriate. We'll certainly live and die with that. Nonetheless, it's contrary to the rule. This motion is contrary to the rule, and we're asking for $1,500 in fees.
All right, Ms. Gilmore?
You want to have Ms. Hyde speak, or do you want to me to go first?
It's entirely up to the
I'm sorry?
Would you like me to present a rebuttal, or do you want to hear from Ms. Hyde?
I can hear from this side. I've read her report. I don't know if you've got anything additional you wanted to add to that. Ms. Height?
Oh, I'm sorry, Your Honor. I thought you were speaking to Ms. Gilmore.
I don't know. Is there something you wanted to add to the report?
I think I would like to clarify just a couple of comments that have been brought up today. First of all, as Your Honor knows, my marching orders are to provide the court factual information in the best interest of Ryder. I take that very seriously. I take my charge to be unbiased very seriously, as you know. I spent a lot of time reviewing information. I had lots and lots of information. I reviewed and read every letter and every document that I received. I didn't feel like all of it needed to be mentioned in the record in order for me to present factual information for Your Honor today. I made my recommendations after long consideration, and I recognize that they are out of the scope of the norm. I particularly would like to talk about my recommendation about the travel trailer business. What I was grappling with there was that Riker needed a place that he could visit with his mom if she was going to be out of the home. He needed a place to visit with his mom where he would be safe and there would be no other adults around, no other visitors around, that she would not have to end up having to go live with a friend or someone else, that she could have this place that would be convenient and inexpensive for her as she's getting into the process of moving from the home. So I did not at all consider that to be overreach, but just as a way to provide convenience for the parties and something that would be in Riker's best interest. I do stand on my recommendations. I believe they are in Riker's best interest. I considered, as you saw in my report, I considered a lot of facts. And I believe that Riker, I tried really hard not to back him into a corner to tell me what he wanted. He voluntarily told me what he would prefer. And I actually went outside of his preferences. He really didn't want a weekend at all. And after he had offered that information to me, I questioned him on it a couple of times to see if that was really what he was thinking. And he said he would prefer to have every week with mom, as I put in my report. And then I added in the weekend because I believe it will be in his best interest as we go forward and as the dust settles and everybody moves on to where, as Mr. Zandy said, people move on. And as the animosity decreases, I think it's going to be in his best interest to have weekend time with his mom. And so that's why I added that in there. So that's, again, I appreciate you giving me the opportunity to clarify a few things. I certainly welcome any questions, but I do stand on my report and on my recommendations today. Thank you, Your Honor.
Thank you. Let's go on.
Extremely briefly, as the court's aware, there doesn't need to be an adequate cause finding for a modification of a temporary parenting plan. A temporary parenting plan is just that. The court in November entered a temporary parenting plan based on self-serving statements of both parties, frankly. One party saying the sky is blue, one party saying the sky is red. The court appoints the guardian ad litem to do exactly this, investigate, and provide a recommendation to the court on what's in the best interest of the child. I don't think that it's in the best interest of the child to set this matter over another potentially 6 months. As Mr. Zandy had indicated, we haven't exchanged discovery, we haven't done a settlement conference, and we haven't even attempted to set this for trial. In the interim, we're looking at another 6 months where this child is having alternating weekends with his father, who it's in his best interest, but pursuant to the guardian ad litem, to live with, while this mother doesn't exercise even the weekend visitation that she has. My client has fully fleshed out some of these other allegations regarding the drinking issues. I would ask the court to look at both the recommendation presented on both recommendations. There is no intention by me or my client to game the system. Again, we received the interim recommendation indicating that it was in the child's immediate best interest to change the visitation schedule. There was a final report set forth, but it was far enough out that we were concerned that we wanted it to be addressed immediately. After we were set over last week, Ms. Height sent both Mr. Zandy and I an email indicating that she was close enough to finishing her investigation that she planned on drafting a report, which she did. We were both on notice that this was occurring, and if there needed to be a set over, there was an opportunity to request that, and I didn't receive that. And I think that, like I said, the report really speaks for itself. I counted while Mr. Zandy was making arguments. She interviewed at least 9 people. She looked at about 29 declarations of the parties. I think that this is a full investigation. I simply don't think that it's going to be sufficient for the courts to defer a ruling on a modified temporary parenting plan in the interim, as this child, again, isn't doing well under the current parenting plan, which isn't disputed by either party. I think it's frankly damaging the relationship that he has with his mother under the current visitation schedule. Again, my client's priority is
I would
parenting.
object to anything that's outside the scope of any declarations. That is not what the GAO report says. The GAO report says specifically, there's no doubt as to either party's fitness as a parent, as evidenced by the child's capabilities and attitudes. I don't know.
I'll sustain the objection. Okay. This is an interesting scenario for a couple of reasons. Mr. Zandy, you referenced a number of photographs which were not included in anything that I've been looking at, so I'm not familiar with those. I reviewed the documents that were filed for this motion.
At the onset of the case was all those photographs.
I understand. I'm looking at the documents, so I haven't looked at those because
Okay.
I reviewed the documents that were filed for this motion. And I wasn't aware necessarily that this has been before the court recently and this was followed on for a request for change earlier?
So there was the initial order from Commissioner Carmi that was then asked to be subject to revision by Mr. Bryant, at which time Judge Hahn reviewed the matter.
Okay, so there was an initial temporary order finding, and then that was the revision. So this wasn't a motion to change that, other than revision. I mean, there's not been another motion like
Yes,
this.
I think that's correct. I think that's accurate.
Okay. I was misunderstanding what you were saying then. Okay. I think what I'm going to do on this is I want to take this under advisement, I could either give you a written or I can set it over for a decision.
I'm fine with a written.
Written's fine. Can we just set something for tracking purposes?
I'm sorry?
Can we set either a review hearing, whether we can strike if we get a ruling, or just something for tracking purposes?
We can do that. If I'm going to set a review, I'll probably set it out to the 19th. I'm not sure if I'm going to be doing this docket next week, so do some other scheduling, but so I can put it on for the 19th for review at 1 o'clock, and I'll get a written decision out before then.
And we were already before the court on the 19th for the final GAL review, so that works for me.
We are. Let me check. We are, looks like. I guess we can just leave, if we can just leave that on for the 19th, and I'll just tracking here, we strike it if I have a decision out to you before. This is probably a case that, I guess, given the urgency, maybe we need to get it on a more expedited schedule. I don't know if you want to, I don't know what kind of discovery timelines you're looking at, but we may want to do a scheduling order for this case. It's probably appropriate. So we'll come back on the 19th. I'll get you a decision before then.
Very well.
I've got Ms. Baldwin. I think I saw
Thank you, Your Honor.
both Mrs. Wallingford. I think I saw them both, but I'm not seeing them both now.
They are both here.
Okay.
Yeah, I'm here, Your Honor, and I am here too, Ms. Petrie, representing Mr.
All
Wall.
right. Very good. I see you there. So would you like to proceed on a motion, or is this resolved, or what are we arguing today?
We have some of the issues resolved, Your Honor, and I'll go through those, but it is my client's motion. So the issues before the court,
Let me
sorry.
stop you for just 1 second then. When I was reading this initially, there is the motion that was set for today, which is the one that was filed February 9th. Correct?
I believe that's correct, Your Honor.
Right. So that motion references a separate declaration on page 6. I have a financial declaration, but I didn't see any other declaration.
Are you talking about my client or the other side, Your Honor?
Your client.
I do believe there was a declaration. I think it was primarily contained within the motion itself.
No, it's separate. It's filed as a separate document.
Then
The one I received is separate.
I don't believe I have that. I mean, what I have is I've got the motion that at the very last page says see filed declaration. And then the only declaration I have that would have been filed on February 9th is the financial declaration.
Interesting. I have one. The one I was served with is conformed, but I didn't get it
It
from.
was filed.
I don't know that I have that.
Yeah. Well, I mean, I don't want to, but Ms. Petrie, I mean, obviously your client's declaration isn't there.
Did Your Honor at least see my reply declaration?
Oh,
Well, I believe I saw that. I mean, I read all the other documents. I just didn't see that one when I was first looking at this initially. Let me see here. The 227 from Ms. Bone. Declaration from Kaylee Christensen, and these are all from Ms. Baldwin's client. When was that filed? The reply?
The reply was filed, I believe, last week.
I don't know that I have that. We got the motion February 9th, and then a proposed parenting plan and support worksheets, that sort of thing. Then I've
The
got,
reply declaration was filed February 29th.
I don't think I have that.
yeah, it
Okay,
looks like the last things in Odyssey are my declarations when I look in Odyssey.
That's what I'm seeing. And then there's an affidavit of mailing, which was from your office.
I'm wondering if it got filed under the wrong case number.
No, I have an affidavit of mailing of a reply declaration that was filed on the 1st, but I don't have that. I don't have the reply or the initial declaration.
Yeah, I don't see it in Odyssey. That's interesting. I received it, but it isn't in Odyssey. Your Honor's correct.
So I guess my thought is if,
misfiled. It's the number, so that your cause number is wrong.
It is, it's the cause number is wrong.
They listed it as 3808, and the cause number is 2508 in this cause number, so it's just misfiled.
okay, well,
Correct.
and I'm familiar with there's some urgency in having some kind of orders in this case on at least an arm's length kind of basis. I think we probably need to have something. I guess my thought is, I don't have any basis to move forward today on anything unless whatever agreements you've got, I could have you do that and then set this out maybe a week or two. Probably.
That's my thought. The agreements, I think, are sufficient to at least keep everyone at arm's length. And my understanding of the agreements, both parties have obtained their own housing. My client's remaining in the family home. Mr.'s obtained his own housing. Both parties agree they're not going to go to each other's homes. They're not going to enter each other's homes absent express invitation from an adult, essentially from the parties themselves. Parties will communicate about the child via our family wizard. Each will pay their own service for that, at least till the child's 18, and then sort of it'll be what it'll be once she's 18. But pending hearing, I think that was largely it, though. Ms. Petrie, was there anything else?
There were, we also agreed to strike the request for the GAL since the child is 17 years old and is going to be 18 this year. There's no need to go ahead and go through that, put everybody through that. So primarily the big issues for Your Honor is the Honda passport, child support, parenting plan. We've agreed that each party will pay their own attorney's fees, and setting a date and circumstance for the exchange of personal property. Those are really the only issues. And I don't mind putting that over for 1 week.
Okay. My only concern is I'm not 100% sure I'll be doing this docket next week. Wait a second. Let me just look at one thing. Probably am.
And I'm okay either way. Your Honor's fine.
No, I do have it down. So, okay. Well, why don't we do this? If you want to shoot me an agreed order with regards to these issues, I'll enter that. And then if you can get the other documents filed, I can make any order I do effective backdate it to today, so we can. It's probably appropriate. I just don't have it in front of me, so I don't know what all we're talking about.
Fair enough.
Right. No, I would rather get you courtesy copies and have you review them. So.
Okay.
And then I would just ask Ms. Petrie if you would contact the clerk's office and just clean those files up so that wherever those ended up being filed, it gets retracted from those places.
Yes, I will get this fixed.
Okay. All right. So I'll look for, and that can be electronically submitted if you want, on the temporary for this next week, and then we'll put it over 1 week to the 12th at 1 o'clock.
All right.
Thank you, Your Honor.
And Ms. Petrie, if you can get me bench copies of those, that would probably be the safest.
Absolutely. I will make sure.
If it goes in, it'll get filed, and then it takes some time to get through the system.
Understood, Your Honor. I'll make sure that happens.
All right. Very good. Thank you.
Thank you, Your Honor.
Welcome. Let me get into this one a little bit. We're looking for some temporary orders. So there was essentially looks like the two of you have agreed to use the letter that was filed February 21st. It's a letter dated February 9th. Is that as a?
Yes, Your Honor.
Okay.
If I may, the last court hearing we had our proposed parenting plan, and because Mr. Fowler is currently in inpatient treatment, he's not able to file anything. And
Right.
so I asked the court if it would be okay with filing his responsive email in lieu of a response. And so that was filed with his permission.
Yes, Your Honor.
So looking at that, and then looking at, I think the requests that were in the parenting plan that your client had filed, there's some pretty significant differences there. I don't know if you think you guys can come to some sort of agreement between those things. Alternatively, it probably needs a guardian ad litem.
Your Honor, what I would say to that is I think that you're correct. The differences are significant. And so based on his response, he does agree with a substantial portion of the parenting plan. And there are about 5 things he does not agree with. And so if the court would like to put a parenting plan in place now and address those issues of disagreement, we can do that. If not, I would ask that the court reserve on a parenting plan until a GAL can get a full report in.
I think that's probably what we need.
And I agree with the GAL as well, Your Honor.
Yeah, I just think that we need to have that in the case because there's enough relatively significant issues. So
Also, Your Honor,
who's next on our list?
there was also a
Let's deal with the GAL real quick. Let me give you the 3. Twyla Corey, Sherry Ebald, and Amy Turnbull. Any objection to? So that's the order they'd go in. So any objection to?
I have no objection to Twyla Corey, Your Honor.
Okay. Mr. Ballard, do you have any objection to Ms. Corey?
No, Your Honor.
All right. So we'll appoint Twyla Corey as GAL. We don't have it. We do have a temporary. There it is. We have a temporary child supporter in this case?
No, Your Honor, we do not, and that was what I was about to address. The only thing we currently have in place is a temporary family law order that does establish my client can get $3,000 a month in combined spousal support and child support, and the parties have been okay operating off of that agreement so far. On the February 2nd hearing, we did get direction from the court in section 14 of that proposed or that motion for the temporary family law order about my client withdrawing $50,000 from the house proceeds escrow. The court said that it was not comfortable doing that, but that she would be able to withdraw $3,000 a month as needed from the escrow account if the joint bank account did not have enough funds in it. And so would the court be comfortable with us putting that into a temporary family law order with a reservation on the parenting plan?
I thought we had done that. Maybe I've got a couple cases that have a similar issue. So if we haven't done that, that makes sense to me.
Yes, Your Honor. What we had done previously was we got a contempt order, or sorry, motion to compel with fees.
That's right. Yeah, if you want to just roll that into a temporary reserving in the parenting plan, and do you want to do up an order appointing Miss Corey?
Yes, Your Honor, my office can handle that.
All right, and this is probably a private pay, I'm guessing, given the numbers that we're doing here. So, but it probably needs to be split up on some kind of a income basis.
Yes, Your Honor, I would request that my client pay either pro rata or less than half based on the income disparity of the parties. Perhaps Mr. Fowler and I can come into some agreement about what that should be and put that into the order.
Okay, yeah, that's what I was thinking.
And I'm currently unemployed, but working on employment, so hopefully that's temporary.
Okay. Why don't you see if you can come to a number on that based on what the incomes that you're aware of. I just don't have that information in the file that I can really base that completely on. And I think there's a difference of opinion about, I mean, if he's not working right now, obviously he's been working at some point, so.
Yes, Your Honor, and I believe Mr. Fowler is currently in treatment, so we would need to be able to communicate with him to get this order put in front of the court for entry. May I ask Mr. Fowler, what is the best way to reach you?
Email is the best way to contact me.
Okay.
Thank you.
And is there any way, Your Honor, that we could assign county pay at first, subject to modification once income numbers are available?
Mr. Fowler, you historically had some pretty good income and you're unemployed at the moment. Is that because you're in treatment or because you're not employed until you get through treatment and need to find another job?
I was laid off on the 12th of February, so it's a fairly recent development.
Okay. And is that laid off on a permanent basis or?
From my understandings, yes.
Okay. I think I'm fine with a county pay to start with. That with the language in there that it may be subject to amendment by the court once we get farther in the case.
Thank you, Your Honor.
Okay. And so, Mr. Fowler, what will happen then is Ms. Holder will prepare up those orders we've just talked about. She'll email those to you. You can look at them, send her back any concerns about the language. And then assuming that you two reach an agreement on that, then she can present those and we'll get them entered.
Will do. Thank you, Your Honor.
Okay. Do you know what your anticipated release date from treatment is?
It's looking like the 1st of April.
Okay, that's not too long then. Okay. But once you get out, make sure that you get in touch with the guardian ad litem. Given that, why don't we put that initial guardian review date out about 45 days instead of 30, just because of he's not going to be too available for a couple of weeks, so.
Yes, Your Honor.
Okay.
With the full, and Your Honor, is that with the full report being done in 90 days?
I think that's probably sufficient given what we have. I don't think we need to put an interim one on just that initial one, 45 days out.
Your Honor.
Yes.
I am out of town the week of April 1st, so anything after the 8th or 9th, I'm available again.
Okay, how about we put it
for
on
the review?
How about the 9th?
The 9th works for the first review.
Okay.
Actually, that's not going to work because I won't have the opportunity to contact Dad until after the first.
You want to go the
And speak
16th?
speak with him. Let's go with the 16th, please.
Okay.
Thank you.
And would, Ms. Corywell, I've got you on there, so if we do that, do you have a time in, say, early June that you'd be able to have a report out, you think?
Yes, that looks pretty good.
Maybe, let's go with the 11th of June. Okay.
Okay.
All right, I'll wait orders.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Good luck and treatment, sir.
Thank you.
Good afternoon, Your Honor.
Good afternoon. We have Corey Gorman.
I think he's in the courtroom, Your Honor.
If you could have a seat there, kind of by a microphone, sir, that'd be helpful. All right, so this one is a little bit confusing as to process of how we got here.
I'm happy to clarify, Your Honor, if
Sure.
you need assistance.
Go ahead.
January 10th, 2024, Corey Gorman filed a motion for temporary orders. We were set for hearing last month. As of the hearing, he had not served my client or me. So Judge Evans asked if we wanted to have him strike it or just reset it. I said, let's just reset it. There's no point. And so we set it out 4 weeks to today to allow us to file our motion and for him to serve his motion. Mr. Gorman did not timely serve his motion. And so what I have is just our motion before the court. But that is briefly how we got here, and no responsive pleadings from him.
Okay. So it looks like, I mean, he filed it. It looked like that was served on the 19th.
Yeah, so it's about a week late.
So, and I guess I looked at the hearing from Judge Evans and I didn't see a date for service, but it just saw service.
Oh, at that hearing, Your Honor, with Judge Evans, he had not served.
No, I understand that, but I didn't see anything in Judge Evans's ruling setting a date for service.
Oh, just regular service for the motion rules because she hadn't been served with the petition or the motion at all. So it would just be the regular ruling.
Okay. So I guess there's a couple ways to do this. One would be I believe your client had indicated not proper timely service and wanting to. Then I got a declaration filed Friday, I think it was.
Yeah, I mean, I guess a couple ways, Your Honor. Like his motion doesn't really say much. It's a couple of sentences. Really anything my client would have said in response minus one line is contained in our moving paperwork. So we'd either ask that it gets stricken or just accept our late response since he served us late. I think in reality, no matter which way you slice it, the issue of custody and visitation it's there through our motion. Anyway.
Okay. Sir, do you want to go ahead and proceed with what we got filed? I guess what I'm looking at, I have both of your positions are filed, what your requests are. And so I could either set it out for some time, let you guys get your paperwork in a little more in order, but I think I have everything I need to probably address the issues.
Well, the only thing I have is I just want to see my kids on a regular basis. I didn't ask for too much in the filings or the motion that I put out. I asked for UAs and she's presented those. So I'm not going to sit here and sling mud because that's just ridiculous. It's not in the best interest of the kids.
Okay. All right. Well, let's go ahead and proceed. Essentially, I think what I'm going to do is, counsel, I'm going to work off of your motion. I'll just consider all of his pleadings essentially sort of the response to that. I don't think there's enough there to get too excited about.
I refute some of that stuff that she's stated in her motion. I mean, some of it's pretty ridiculous.
Okay.
And Your Honor, we're going to object because he didn't file any pleadings.
Right. And you would have needed to file something. So in order to do that, so.
Well, can I seek counsel in this? Because I don't want to sit there and just take this motion that she's got the way it is because it's not fair at all.
Okay. Well, you were served a motion, correct?
Yeah, he was served timely, Your Honor. He makes like 130 grand a year. He's had since January to obtain counsel if he wanted it.
I do not. make
At this point, at this point, he's just playing games. Like, we thought we had an agreed upon parenting plan. We made multiple changes. We never got signatures back. This is just delay tactic after delay tactic. We've tried to make it as easy for him as possible. So he certainly can, but my client has a right to move forward today. She's not getting support. He's the one who makes all the money. So certainly if we go forward today, if he feels like he needs to amend it or something, once orders come out, he can do that. But he was timely served. My client wants to proceed today.
Well, I'm fine proceeding today. I mean, I've got two financial declarations. They're quite a bit different. So I don't have any financial documentation, so I have to work with that. But
And we did submit financial declaration for him, Your Honor, contained in our sealed source documents.
Yeah, those are old documents that she had obtained from a file.
well, hold on, just a second, sir.
So in our sealed source document, Your Honor, we submitted his 2022 W-2, and then I just did a simple cost of living adjustment for each year. I gave you the proof of the cost of living adjustment to come up with his income. And then I presented my client's income at her hourly rate at full-time wage. And her year to date, it's not that much difference. We're talking like a $200 difference in child support. So we've provided all financial information to show what he makes. As you can tell, the proof that we've provided is quite a bit different than the random number he writes down with no proof. Again, he had plenty of time in which to do a response, even a late response, and he failed to do it. He failed to provide income documentation when he filed this in January. So what she's provided, there's no way for her to fudge it. She's provided a U.S. government form that is his W-2.
That's an old W-2, and that doesn't provide what I make now, because I don't have.
And Your Honor, again, we'll object.
Okay. All right, counsel, just a second. One of you talk at a time, please.
I don't make the same amount of money as I did then. I had a lot of overtime back then. I don't have the overtime now. I sit behind a desk.
And Your Honor, we're going to object to anything he said, as he's not filed responsive pleadings. There's nothing in the court file that indicates this.
Okay, well, I have a declaration as to his current income, which is a declaration, which is evidence the courts to consider. So I have a document from 2022. I'll listen to your arguments.
Okay.
Go ahead.
Did Your Honor want me to go through everything, or we're not proceeding by default. We're just going to take, like you said, his response his motion as a response in his financial. Okay. Thank you, Your Honor. I know Your Honor reads everything quite diligently, so I will try to be brief. My client has always been the primary parent. She was a stay-at-home mom or worked virtually very part-time jobs up until the parties separated July 2023. She was, the typical mom, did all of the raising, did all of the rearing, the medical appointments for the child, the school, versus opposing party. While his technical workday doesn't start until 7, he'd be up at 4 a.m., out in their shop by 4:20 in the morning, then off to work, and wouldn't come home until 5 to 7:30 at night. It was only recently after they separated that he finally took an interest and went to one of his son's IEP meetings. When he moved out and the opposing party moved out July 2023, he saw the children through December every other weekend from Saturday at 7 to Sunday at 5. So basically one overnight every other weekend with a Tuesday dinner visit. My client had agreed to Friday to Sunday, but he didn't want to do that because he'd rather be out drinking with his friends. He currently lives an hour away from the children's school. He lives on a fifth wheel in somebody's property. While there is a room in the back, the issue is that it's too cold in there. My client has no idea where the children sleep. If you look at the exhibit that we had attached, you'll see that, 2 children, not the baby, scrunched up on the couch that surrounds like the dining room table of the fifth wheel. That's certainly not
Hold on one second, sir. One at a time. Don't interrupt. I'll listen to what you have to say.
All right.
Go ahead, counsel.
That's certainly not an appropriate place for children to sleep, is scrunched up on a table for a dining room. She's 12 minutes from school. He's an hour from school. Since January 2024, he's made little to no attempts to see the children. He might ask about them, but he never did anything until I jumped in January and said, let's try to make an arrangement. I asked what he wanted. He told me what he wanted. My client agreed to it. The next day he changed his mind. This is a pattern with Mr. Gorman. He says one thing, changes his mind. For example, the last court hearing that we were at, Judge Evans instructed him to call me. He never called me. I called him. He then told my client, your attorney's a liar. She never called me. And I sent my client proof that I had. I think the biggest thing right now that my client has is Corey has a serious drug problem. He's addicted to a variety of things such as meth, alcohol, and marijuana. From 2010 to 2023, he used meth every single day. This is not an allegation. This is what my client saw him do. This is not hearsay. She saw this with her own eyes. The last that she knew of him doing meth was a few weeks after she told him to move out in July 2023. She didn't want to be a part of this drug addiction anymore. The last time she saw him use meth was July 21st, 2023. Corey has a addiction problem. He goes from one to the other, meth to alcohol to weed to meth to alcohol. He just changes up one for the other. He admits his alcohol drink of choice is whiskey. In our sealed health documents, we submitted his journal that says that he got drunk off whiskey and was hungover, and he admits to drinking too much and he slept all day. He has had some visitation. So he finally started up visitation again mid-February. It was either the 16th or the 19th, whatever that weekend was. But it was only while he is on the property of Megan and Mike, which is where he is now. That is the only reason my client is okay, because basically Megan does the vast majority of rearing of him. Bathes the children, she's involved. That is the only way, based on his addictions and his lack of involvement, that she is okay. She is scared to death of him taking care of the kids when he's alone in his active addiction and is taking 0 steps to do anything. You know, he's not in any kind of treatment. He hasn't gone to any kind of AA. He's not doing anything to recover or be clean or sober. He hasn't submitted any UAs, nothing. Additionally, we have some concerns as when the parties lived together, Corey kept black powder in the house, so he was making illegal fireworks and explosives. That is stuff that he had since taken. We don't know where it is. Is he making fireworks when the children are with him? We have instances of him spanking. He spanked so hard once in front of the daycare called CPS, and the child Hunter was not allowed to come back anymore. He's constantly yelling at the kids. He's talking down to Hunter. When my client admits my client went to treatment, she has been clean and sober since December. The day she got back, Corey tried to withhold the children. He drove by the house because he wants to talk. He always wants to talk. He's trying to engage. That's all he wants to do, is get her to come to the house, get him to go up to his house where he's staying. He tried to withhold the children. Meanwhile, the children, one got out of the car, one jumped out of the side car and ran into the side door of the car in the back seat and ran into the house. And my client unbuckled the child, but he was trying to tell her, you're not getting the kids, you're not getting the kids. Well, the kids were so excited and didn't want to be there that they ran into the house where she was staying with her parents at the time. He really has had no bond with the children until after he moved out. That is when he finally is starting to slowly creep and do something. He has an extensive criminal history and court case history. We submitted documents showing that he has 11 court cases, including a DUI in which he caused an accident. Regarding child support, he has provided a declaration from January. His financial declaration makes 0 sense. There's no supporting documentation. He just writes a random number of, I make $7,600. He fails to provide any pay stubs for 2023 or 2024. He provides no W-2 for 2023. He's just making up a number, versus my client who provided a 2022 W-2 stating he made $121,581. Even if you were to divide that by 12 and you didn't do a cost of living adjustment, that's over $10,000 a month. He can say whatever he wants, but there's a reason he's not submitting financial declaration. If he was truly making less, then why hasn't he submitted it? This month right now is a very high month for him to get overtime. He almost wasn't able to come to court because they're having some big thing at work. So he wasn't sure if today was even going to work. We simply took a government issued document and adjusted it for cost of living. And that's how we got $132,158.76. My client just recently started working full time. So we presented 2 child support scenarios, one with just her hourly rate at 40 hours a week and one with her actual year to date. The difference between the 2 child support numbers is like $160. So Your Honor, if you want to go with her at full-time income, that's fine with us. It's $2,214.14. Additionally, my client is asking for spousal support. Opposing party hasn't provided any support since their separation. He bought diapers one time. He's left her with everything, all the bills, everything to do. He makes 4 times what she makes, and he's not contributing. You know, my client wants to return to school. She's working at a vet's right now as an assistant. She wants to return to school to become a certified vet tech to improve herself financially for her and the kids. That's going to take 2+ years. Depending on the rest, because we did ask for bill payments and everything like that. I understand there's only so much money to go around. So depending on what your honor orders, she would need at least probably $800 a month. With that, of course, depending on what else is ordered. He, family residence, he moved out in July 2023. So we're asking my client to have exclusive use. I don't think that'd be an issue considering he's moved out. The issue we have is in December 2023, he changed the locks without telling her or telling anybody. It took me jumping in and a month later for him to finally change the locks back. And he was like, I have keys, but he didn't want to give her the keys because he kept saying, come talk to me, come talk to me. That's his way to get her is, I will give you the keys, but you have to come talk to me. So one of our asks is that he not be allowed to change the locks. My client makes about 4 times less than what he makes. She doesn't have the ability to pay for attorney's fees and costs. He's living in a trailer. He doesn't have the same costs as she does, the same utilities, the same expenses, the expenses for children. He makes $132,000 a month. Even if I were to take his financial declaration as true, his expenses, which are not all of the expenses because he wasn't paying the mortgage, he left her to pay that. So there's various expenses he's not even paying. He's not paying food for 4 people. He has plenty of money left over to contribute. The last ask that we have is that, or I guess we could go into his motion if that's going to be his response. He had a 6 or 7 line motion. Unfortunately, everything that he wrote in there was false. He said that when he filed this motion on January 10th, he said my client was inpatient treatment. My client was in treatment at that time. She had been out for, I think, at least a week or so. So they weren't in his care full time. She wasn't in treatment. He doesn't have the ability. And he didn't ask. He just told Your Honor he asked for UAs. He never asked for UAs. We provided them, though. My client has nothing to hide. So we're asking that the court adopt our proposed parenting plan, order a child support number somewhere between 2214 and 2386. We have proposed that the tax deductions are divided equally, 2 in one year, 1 and 2 the other. So she's fine with that. My client to remain in the house, spousal support of $800. We ask the court order our use of property, protect property, household expenses and debts per her motion. Don't change insurance, attorney's fees of $2,500. Our family wizard, and for him not to change the laws. Thank you.
Sure. Your response?
Yeah, okay, so, yeah, she works full-time, or at least she says she does, until 5:30 every day, but she wouldn't come home until after the kids were in bed. Now, yeah, I was out in the shop a lot. I make knives on the side. I used those knives to pay the bills and to pay for her drugs that she was doing as well. Okay, I've never denied my parentage. If I did it by mistake because I'm not an attorney. I don't know this paperwork as well. I've tried. It's a lot. I tried to get them whenever I could Fridays, and I don't drink very often. The one time that she's got me on my little, in my private journal that she somehow managed to get a hold of, it was one Friday. Yeah, okay, I'm weak. I had a Friday that I got drunk. Sorry. I don't use drugs. I haven't used drugs since the end of July. I have no problem taking a hair follicle test to prove that. And my doctors recently told me that I can't drink alcohol anyway because of my liver. So I don't drink because he said I can't, and anything else. And the children do have beds in this trailer that I have to live in. However, they've always usually 2 of the 3 migrate to my bed to sleep in it with me, even though they have a bed to sleep in. There is plenty of warmth in this trailer. I have multiple heaters, and there's a furnace in it as well. It's very well insulated. It's a Polar King, so it's not cold. When I did have them for the month of December, when she was in inpatient treatment, they were always on time to school. They had to get up an extra hour early, but that's fine. I mean, they got up at 6:30 instead of 7 o'clock, and they were at school at 8 o'clock every day. I picked them up directly after I got off work because I had to change my work schedule in order to keep these children during that time. after the 9th, when she got out of inpatient treatment, I had the children waiting there. They were at the house with me, waiting for her to come home. They were excited to see her. I was there to give, let them see their mother. When she didn't show up down at the house, I drove up to her parents' house so they could see her. That's how my son went to the door and knocked. I told him to get out and go knock to see if your mom is there. When he saw her, she went inside. He went inside. My daughter ran out afterwards. She came out, started getting my son out of the car, at which point I tried to talk to her about the kids. All she said was, talk to my attorney. She wouldn't talk to me at all. I tried to make efforts to, be amicable and make a parenting plan with her, but she didn't want any part of it. She just said, talk to my attorney, and I had no idea who that was until like a half a week before the first court date. So, and in that time after she took the kids, she blocked me on any way of messaging her because all I had was Snapchat. I didn't have cell service up there as a trailer at the time. I do now. So all these Snapchats and everything else where I tried to talk to her and tell, at least have her tell the kids I love them and all that. She just blocked me. So I couldn't talk to my kids. And all this other stuff in here that she's not showing all the information, and a lot of it is false. Like this methamphetamine use and alcohol and marijuana use. I'm sorry. I quit doing drugs in July. I don't have a problem. I just quit because I knew it ruined my life. I have no problems not doing drugs. I don't want nothing to do with them ever again. That's something, the part of my life that I don't ever want to see. Now, I'm sorry that she chose to keep doing drugs after July, clear up until December. When she finally,
there's nothing that says, he's going way beyond what's in his motion. And he has not filed anything.
You just need to focus on documents you've actually filed, sir.
Well, I didn't get to file any of the documents because I didn't know which ones to file. I'm not an attorney. I tried to get as much stuff as I could as possible.
I'm looking at what you filed as your response, so that's why I need to have you stay within that.
Okay, well, I guess none of this matters. So I could provide you the documents that you like. I have them right here in front of me, even though I don't know, the timeline is kind of wrong, but I've got my pay stubs and all that stuff. It just shows that I don't make that much money. I may have in the past. I do not now.
Your Honor, again, we're going to object. It's outside the scope of anything that's filed.
Overruled. He filed a declaration, counsel.
But he's saying he has pay stubs. Those aren't filed.
I'm not looking at the pay stubs, counsel. I'm looking at his declaration. So go ahead, sir.
I'm not sure what else to say here other than, I've gone so far as to take a parenting class, an anger management class, which she wanted me to take as part of her little parenting plan or whatever else. The parenting class.
Again, Your Honor, we're going to object. It's not in anything that's filed.
The anger management was part of your parenting plan.
Well, it's not what you filed in your responses. You can only comment on the responses that you filed, sir. Okay.
And Your Honor, if we just have a brief reply under a minute.
Sure.
Your Honor, the vast majority of what he just said is outside of scope of anything that he's filed. He's admitted now multiple occasions that he did use drugs. He said that twice now. Whether or not he's still using, we don't know, but he just admitted in the court he at least used drugs until July 2023. Additionally, he only watched the children part of the time. My client was out, her parents did it the other part. He also states that she blocked him, but he just admitted he didn't have cell service up there, which is what he has communicated to me, which is why sometimes we couldn't get a hold of him. Thank you, Your Honor.
Okay. So first off, obviously we have two people who had relatively significant history of using drugs or alcohol or something. So I'm going to need a guardian ad litem since there's a difference of opinion about the parenting plan. So we're going to need a guardian ad litem. So who's next? Would that be
Sherry Evald,
and
Amy Turnbull, Beth Fellows.
so Sherry Evald, Turnbull, and Fellows.
Yes.
Counsel, any objection to Evald would be the first choice?
But I think I would strike her, Fellows or Turnbull.
Okay. Do you have any objection to Ms. Turnbull? Okay, Ms. Turnbull would be next, and so appoint her. At this juncture, the only information that I have information that shows last year's tax information. I don't have 2023 income in front of me. So at this point, just a minute here. At this point, what I'm going to do, I think, given the circumstances, I'm going to require both parties to do a current drug test, including alcohol, and both parties to do a current hair follicle test. There's enough concern there raised on both parties, so obviously that's something the court is concerned about, and that'd be something the guardian ad litem can look into. There doesn't seem to be any dispute over use of or where they're living or that sort of thing, so that just to continue to keep the property they each have and reside where they're residing. I would put a restriction on changing any locks. Neither party should change any insurance policies or that sort of thing. As far as finances, I'm going to order $3,000, and that'll be family support, since I'm not real clear on all the numbers, so that would work out about to what the request was. And then on the, I'm going to reserve on all of the findings under paragraph 3 for both parties till we have more information. Both were requesting that. I don't think I have enough information today to make an actual finding on those. And then as far as, I don't know they have anywhere in here what, Mr. Gorman, what are your work hours?
I've changed it back to 7 to 3:30 since I don't have my children.
7 to 3:30.
7 a.m. to 3:30 p.m.
Is it 4 on, 4 off?
No,
What's that, 5
Monday
days
through
a week?
Friday.
Monday through Friday, okay. And your client, counsel?
She's on. She can let you know. I apologize. She just works the regular hours.
Just Monday through Friday?
Yeah, no, I think she works on Saturday.
I work 9 to 5 or 9 to 6, Thursday through Tuesday.
Thursday through Tuesday?
Correct.
So you work Saturday and Sunday?
Correct.
Okay.
And her parents are basically across the street, and that's who will assist.
Well, given that, and given the, I mean, historically, there apparently was no problem with him having the kids for a significant time, a month or two ago. My thought,
That was only because he was with Megan and her boyfriend. That's the only reason she was okay with that. He is now stating that he is going to be moving. So if he's going to be moving, my client's going to have concerns. Active addiction, who's going to be there to watch the children.
well, my thought at this point, would be to, I mean, you're both raising concerns about the other. And I don't have current information that tells me where either of them are on that.
We submitted sealed source that has any UAs that shows any treatment that shows that she's clean. I mean, again, my client is fine with weekends so long as he's residing at Megan's property until he does the evals, the substance abuse, mental health, all of those. She's fine with that so long as he's there because she knows Megan's helping. If he's not going to be there, if he's not doing the evals, that's where she has concerns. She's the only one who submitted anything to show that he's clean. He submitted nothing.
A minute here.
Yeah, we submitted a UA from January 12th, January 24th. We submitted completion of residential treatment. as part of our sealed health filed February 13th, 2024. And her UAs were quite extensive. They did natural and semi-synthetic opioids, synthetic benzo stimulants, other substances, meth, coke, marijuana, heroin, fentanyl, illicit benzos, and psychoactive substances, all negative. And that is what the parties used together with methamphetamines. Her UAs show that she is clear. She had to randomly test as part of her treatment, and she was clear.
All right, well, let's get a current from both of them.
That's fine, Your Honor.
And so on the visits right now, I'll order that he have weekends so long as you're remaining at that location. I'll leave it there until I see drug tests from both of them.
Thank you, Your Honor. Are we doing a Friday to Sunday?
Friday to, she's working all weekend?
Yes, but she's
Okay.
off at, she gets off anywhere from 5 to 6. So
Yeah.
I don't know if it's easier to do like 7 to 7.
And you get off at
3:30.
So, and
And then he has like,
what are the kids?
he has like an
on
hour plus
Fridays?
drive. Yeah. Maybe 7 p.m. would be better on Friday and Sunday for the exchanges, because it'll assure that she's off work. And then as he takes some time, sometimes he does work a little later, even if he gets off at 5:30 or 6, 7 o'clock gives him time to come down and pick up the children.
I thought you said you're working 7 to 3.
7 to 3:30 every day.
To 3:30.
Yes, but sometimes he works till 6 and he's also an hour away. So if he works till 5 or 5:30, he's an hour away. 7 o'clock would make it easy.
You want to go 7 to 7, so Fridays to Sunday?
Fine.
Okay, 7 p.m. till on Friday to 7 p.m. Sunday.
Thank you, Your Honor.
And then on the parenting plan, there's a whole bunch of stuff in there I'm going to reserve on until I get some information from the guardian. Or I see drug tests that tell me something different. So like I said, we're going to reserve on paragraph 3 and reserve on paragraph 4.
Okay.
I mean, order that they each do a drug screening currently, but
And for the drug screening, Your Honor, can we make sure that it includes methamphetamines, alcohol, and marijuana?
sure, yeah, just like a 9-panel.
Thank you.
And let me just see here.
Mm-hmm.
So there's a whole bunch of information about, wait a minute, that's the wrong one I'm looking at. On both of them, there were some restrictions on visits, and at this juncture, I'm going to, so in the paragraph 4, that should be reserved. It should be joint decision, that's what they both have down. And then my thought would be is we'll set a guardian ad litem review date about a month out, and I'd want to have drug tests prior to that time. So if we set that on for the 2nd of April, so I need to have each of you do a current drug test and a hair follicle test to be submitted to the court by that time. So I have that to review.
Your Honor, can we also have an order that they are to exchange it with the party? So we would serve Mr. Gorman. Mr. Gorman would give us a copy of his.
Yep. So send her your copy, send one to the court. That'd be filed under seal. There's a cover sheet that it isn't a public record then. It's for the court only. And then I think everything else on the visitation at this juncture, I'm going to reserve on, and then we can talk about that once I see the drug testing.
Okay. Even section 14, Your Honor.
Let's see what you've got there. A lot of stuff, and that's non-standard language. I would reserve on 14.
Okay. And then just to be clear, when you say reserve on the rest, just reserve on holidays and summers and just follow the weekend. Okay.
Yeah, and we do. See, do we have any holidays coming up in the next month or so that are going to be any kind of an issue? I think so.
Easter, maybe? Wait, no.
That shouldn't be. Or if you want to talk about that as far as when we come back on the,
That's fine.
in April, we can do that. All right.
And
You want a
couple,
presentation?
oh
You want
yeah,
a-
what about our order for household expenses, debts, and payments? Because even with the family support, my client's not gonna be able to take care of all of that.
I've been
So
making
we had,
payments for 6 months.
I mean, the last time we had, he was behind, but if he wants to agree to make the mortgage, that's great as well.
Not making the mortgage payments and paying that much in child support.
So yeah, he hasn't been paying the mortgage, so he makes 4 times as much, like she can't pay the
The mortgage is
mortgage and all the
paid until
car
April.
Okay,
insurance.
sir, one at a time. I'll be happy to hear your side of this, but I can't hear both of you at the same time. Let me look at the budget again here. So I will require him to pay the mortgage at this point. I'll reconsider that if you can provide some documentation that can convince me the income is different. So,
I can provide that right now if you need
well,
it.
you need to provide, you need to file it and provide a copy of the side. We'll take a look at it.
Okay. Like I said, the mortgage is paid through April.
That's great. That's good.
So
So
I need to provide that documentation as well?
if you've got it paid, that'd probably be good because there's some, I just sort of comment that it's not being paid or
It's
something.
paid, and I can go down there to the bank right now and get the
Okay.
receipts from such.
Okay.
That's great. And then just 2 things. What is this? Is the start date for the family support February 1st? And how are we ordering payment of Amy Turnbull? Oh,
That'd be off of the, I'll use your child support worksheet for that.
okay. Okay.
And then on the, let me see here, when did this, order start date for March 1.
Okay. So then for the March 1st, it's just forthwith since we're past.
Correct.
And then the rest of the payments, are we reserving over those? The rest of her requests? For the payment of bills, and then we had attorney's fees.
Well, I'm going to have, he'll pay the house payment. They each pay their
Okay.
car insurance, which is what she's got down. And I'm assuming that, I don't know what she's asking for in the credit cards because it's got both paying those.
Split them in half is all she's asking. She just wants an order that each pay half of whatever the monthly bill is.
So why don't we, and I don't know what the totals are, but if the payments are 50, why don't we have each of them pay one of those?
Yeah, so the 3 credit cards, the total is 200. It would be probably just easier if he just sent her $100 since the cards, I believe, are in her name. So if he just sent her $100 starting March 1st for payment of those 3 credit cards. And I think he already pays the Kaiser and Delta, so if it just stayed the same.
I've got 2 credit cards.
Oh, I apologize. Animal Health Services is just a bill for their animal. So that's where the $100 payment was. The other 2 credit cards are in her name, so he can't physically pay it. So if he just sends her a payment of $100 every month for those 3, and then he already pays the health and dental, I think that would cover it, everything.
Okay, well, I just ordered family support. And I guess
Yeah.
based on this, it was assumed that would be, I assumed the way this was laid out, that they were each paying their own version of that or something.
No, I apologize. Yeah, that, she just wanted them to split it. So those 3 accounts are $200 total. So she's fine, even though he makes 4 times what she makes, she's fine splitting it in half. So it'd be $100 each.
And are those all in her name at this point?
Yes.
Still comes to her. All right, so we'll make the family support $3,100.
Okay, perfect. And then he's to continue to.
And then she would pay those.
Okay, that's fine. I'll put that she pays cards. And then he'll continue to pay the health insurance because that's what he's paying, health dental.
I assume that's coming out of through your work.
Yeah.
Yeah,
Okay.
so I ordered not to make any changes to insurance.
Okay.
I assume that
And-
comes out of a check ahead of time.
Yep.
Okay, so I'm not,
Okay.
that's not an extra payment.
Okay. And then attorney's fees, are we reserving? Are you making
I'm
an
gonna
order?
I'm gonna reserve on that.
Okay, perfect.
And I think I'll include, given that there seems to be some communications issues, that Family Wizard, as part of the parenting plan, as opposed to the temporary orders, is probably
Okay,
a better place to put that.
I can go ahead and add that, Your Honor.
I don't know if you saw that language there, sir. It's on what's an app for your phone where you communicate back and forth. So it keeps you both from getting into trouble. Okay.
Thank you, Your Honor.
You want a presentation date, or do you want to do that when we come back?
I'd like a presentation date.
19th?
Yes, that works. The afternoon, Your Honor.
Correct, be at 1 o'clock.
Thank you, Your Honor.
All right, so she's going to send you copies of the orders we just talked about. You can sign them if they say what we just talked about. If they don't, come back on the 19th. We'll make sure they say the right thing. Okay.
Thank you, Your Honor.
Peters welcome. And Brown better. And do we have Miss? Yeah, Miss Day here as well. Thank you.
And I guess I just have one quick question that is somewhat not related to the motion, but the parties are supposed to be, I think, in a reunification meeting today at 4 o'clock, and obviously they're both still here. I'm not certain how long this is going to take, and I guess my question is whether or not we need to instruct our clients to maybe reschedule today's meeting with Ms. Rosen.
Your Honor, my client is prepared to have his visit. It's already been set. There's no reason the visit shouldn't take place. This is the 1-hour visit he gets a week. The parties can either leave if Ms. Teethers has not made arrangements to have this child dropped off separately. If she's appearing here, it's her choice to appear. So I would ask that these parties, that this visitation go forward. This is completely unfair that it would not go forward today.
We're not taking testimonies. So, I mean, they have a right to be here, but they can take their phone and watch as well if they want to.
Okay.
So, and I don't know, it's not quite 3 o'clock. Each have 15 minutes, so should be able to be done.
All right.
So there's actually, I believe, when I looked at this, it looked like there's really 2 motions.
I think, Your Honor, this was the court reset this for the review of the guardian ad litem report, to have a report finalized. That's been finalized. It's been provided to the parties. It's also been filed with the court. Also, Ms. Day is present here if there were any questions. And then my client had his own motion relative to having the court order that the parties continue to follow the recommendations of Ms. Rosen, who was appointed by the court for the reunification.
And I see the, I'm sorry. Did you say something? Oh,
I didn't.
Okay, I'm sorry. I'm just hearing something in the background then. I understood that, well, at least it's my understanding that these final GALs are simply place markers to ensure that we've received the report. There's not been an affirmative motion or the matter hasn't been set for trial relative to Ms. Day's report at this juncture. We have received the report. I received it, I think mid last week, maybe Monday last week.
Right. Well, I guess the only motion, I mean, it's on to review the final report, which has been filed, I believe. That is final.
Yes.
And then I have the motion that was filed on 2/12, which is the one to follow Reunification Counsel recommendation.
That's correct.
I think that's the only motion. So okay. So the final report is here, so we can strike that motion.
Okay,
so
thank you.
So I guess it would be Ms. Poplawski's motion for reunification recommendation.
Sure. Thank you, Your Honor. May it please the court, counsel, Ms. Day, and the parties, if they're still present. Your Honor, I know the court has read through everything. This is a pretty voluminous case and file. And so I appreciate you taking the time, not having a lot of experience with this case. As the court is aware, my client has made a motion to approve the recommendation of Ms. Rosen and the reunification team relative to what they're suggesting is appropriate going forward. It's really unfortunate, quite frankly, that we should actually be here and it wasn't a simple and easy thing to just agree to this. These are individuals, these are experts that Judge Fassett had particularly appointed to do this reunification, who had entrusted to ensure that this was going to be done appropriately and the parties were going to cooperate and things were going to go forward. As you can see from the file, my client's declaration, even getting Ms. Teethers on board to have this moving as quickly as the court had suggested and had wanted and had made in its oral ruling was a task in and of itself. Nonetheless, my client finally has his first visitation on December 9th, I believe it was, even though it was expected this would happen quite sooner than that. We have a recommendation from Ms. Rosen and her team. As you heard me just briefly mention, my client gets 1 hour of supervised visitation with the reunification counselor present once a week, so on Tuesdays. The recommendation by Ms. Rosen essentially is to increased by 2 hours per week. That would be a total of 3 hours of the supervised reunification visits per week. The other recommendations essentially are to continue, that the child continue in this reunification therapy with Suzanne Snow, to have Lauren remain in her individual counseling, and then also to require both parents to meet with Ms. Rosen individually to talk about the parent impact on reunification. And she specifically states this individual parent session will be used to build additional skills and understanding about reunification and address ways both parents can best support Lauren in this process. Now, in reading the guardian ad litem report, Ms. Day is in support of this as well. So here we have the court-appointed guardian ad litem who supports this. Here we have the court-appointed reunification specialists, the experts in this field, who are making these recommendations. Everyone is on board except Ms. Teeters. In fact, she's so not on board that she essentially wants this court to strike and remove Ms. Anderson from the counseling, which was also the court had appointed to be the counselor. She is suggesting that dad completely, all of his visits be suspended, and that the only counselor that is involved essentially is the counselor that she selected, Ms. Delaney, with the Cowlitz tribe. Now, she had wanted this counselor previously, and that was rejected by Judge Fassett. And particularly, it was stated that it would be Ms. Anderson that would continue with this. Now, it's interesting that, and again, I don't even know if that could even be considered what she's suggesting, because she didn't file a separate motion for that. Again, it's my client's motion to follow the recommendations, which is to increase and to have the continued therapy and to actually have the parenting sessions. There was no separate motion filed by her to suspend the visits. There was no separate motion filed by her to change any counselor or to remove a counselor. So I don't even know if that's before the court, but I do want to address it in case the court is going to consider that, because I think it's important when you actually look at everything that's been filed, including the things that the guardian ad litem points out. When she talks about Ms. Teethers, well, I don't think Ms. Anderson is appropriate. She's not doing her job. One, she's a professional. She's trusted by this court. She was appointed by this court to be the person. But again, Ms. Teethers knows better. And she says her reports are vastly different than the reports of the counselor that Ms. Teethers picked herself. Now, when you actually read through all of the documentation, what's really interesting is that's because we have someone independent who's actually doing this independently. And that's what the court wanted, because there was so much concern over the influence of mom in this entire process from the origination of these allegations. The original allegations were never made just by Lauren. They were always came primarily from mom. And then mom made the allegations and then went and reported to all of the individuals, this is what my daughter was saying. It wasn't specific allegations that came from this child. And you fast forward to even the sessions with Ms. Delaney. It's mom's information consistently being provided to this counselor ahead of and during sessions with this child. So much so that you see in the guardian ad litem report, also in the other documentation, that mom, when anytime there's any report of any such allegations, when this issue comes up, it's mom getting angry, it's mom crying, it's mom completely emotional, it's mom questioning this child. And this is all this stuff being done in front of this child. So one can imagine what this 5, now 6-year-old is going to be responding or thinking when she sees her mother, who she's been primarily with all of this time, reacting this way. And then you also see many of the times counselors and professionals having to say, stop questioning this child, stop redirecting this child, and even the concerns that are raised. You also see this raised in a similar capacity in Ms. Rosen's letter, where she says, Lauren seems confused about the information that she has about what will happen in the reunification process. She shared a concern that was going to have to go to her dad's house during the last visit, although this was never talked about in their sessions. So there's some sort of prepping that's going on of this child, which is completely inappropriate to do. And it's really in an effort by mom to kind of manipulate the process. And this is why she doesn't like what's happening with the individuals that she didn't pick, because they're not aligning with her. Okay. And they're pointing out some of these things that are happening. Ms. Rosen also then says, frequently acts as if she needs to keep secrets during the visit about aspects of her present life with her mother. So you see these things kind of rearing its ugly head with these independent individuals. And of course, mom doesn't like this. Lauren may feel the need to express loyalty to one parent, which may interfere with her ability to be in a relationship with the other. So we can only imagine what would happen then if we get rid of these independent individuals and we put this child solely with a counselor that was selected by mom, that mom completely is the one providing the information, that mom has been influenced in all of these sessions. And so this is a real concern that we have, and this is really even also expressed when you look at the guardian ad litem report. And it says, and this is on page 26, Ms. Rosen indicated.
Well, Your Honor, I guess my concern and objection at this point would be that while we've got the guardian ad litem report, we've not had an opportunity to provide responses to the court, and there's not a pending motion. So I guess my concern is utilizing.
The guardian ad litem report looks like it came in on the 26th, just about a week ago.
And Ms. Teeters started putting in documents afterwards as well, counseling records. The guardian ad litem is also here. And this really just kind of expands on what Ms. Rosen has already stated in her letter to this court. And it basically is that Lauren has made disclosing statements during the reunification process, and those have been appropriately reported to authorities. However, those statements do not match with her emotional presentation or participation with the visitation with father. And that is so incredibly critical here. Ms. Rosen indicated the goal of reunification counseling is to help the child have a safe place to be reintroduced to father and have specifically supervised and safe contact in a supportive therapeutic setting. Lauren does not present as fearful or resistant to contact with father, and she often presents as needing more time in visitation to express herself. And Ms. Rosen expressed concerns about the information. Lauren is confused about the reunification process and needs to keep secrets or demonstrate loyalty to one parent. And I think that that is really important because this really goes to show the concerns we've had historically and repeatedly with Ms. Teethers, and that she's constantly trying to redirect how this process goes because it's very clear she does not want this child to ever have a relationship with dad and for dad to ever be in this child's life. She put it in her own declaration. She wants to completely suspend this. We know that she's having this child call her new husband dad. There's my client put in his declaration, his understanding is she wants to change the child's last name. He's now being called dad.
Well, I'd object as to speculation and lack of a basis of knowledge to make those claims when he has had no contact with my client in the last year.
My client, Ms. Teethers, has not refuted this. It's in the records where he's now being called Dad Allen and not
Right.
Dad.
I'm not sure how relevant that is to the decision today. So.
And so, Your Honor, well, I think what's really important is the real motive here, I think, behind Ms. Teethers. This is not to support this child because it's very clear that Ms. Rosen even wants to have specific parent meetings to talk about how you support this child and these things that she's recognized that just don't match up. And it doesn't appear that Ms. Teethers is supporting this reunification process. And that even goes to show when you talk about what was happening right before the visitation started, where there were allegations that this child was acting out in school and doing things that she hadn't done before. And when the teacher had explained that she believed this was because mom just had a new baby, no, Ms. Teeters comes back and says, not this has to do because dad is going to have to be reunified with the child. So she wants to continue to try to align other individuals with what her perception of what's going on, as opposed to the independent individuals and their statement. And going to show you that, interestingly, after the visitation starts on December 9th, then we have the Christmas break. The child comes back from the Christmas break, which is after she starts seeing dad, and she's doing well. So again, when Ms. Rosen says, geez, the behavior of this child does not match up with what is being said by mom. And interestingly, the child shows up, she makes a blanket statement about, I don't want to see my dad, or he knows what he did, or I don't want to talk about it. And basically that's it. And then moves on with the visitation and everything's fine. And so what does that tell you, or what can you probably glean? Something's being prepped with this child. And that is just really explained out in Ms. Teether. Visitation should be suspended. And let's get rid of these experts who do this day in and day out and go with my person that I've been the only one being able to provide information to. Highly inappropriate. The court appointed Ms. Rosen and her team to do these visits. The court said it's Ms. Anderson doing the counseling. These individuals should remain, and we're asking that the court follow the recommendations, and the guardian ad litem supports this as well. We actually would ask this court to follow one of the recommendations, which is a mental health evaluation for both parties, because clearly something is going on here. Thank you, Your Honor.
Thank you, Ms. McLean.
Thank you very much, Your Honor. While I too anticipate and expect that the court has reviewed the majority of this court file, I want you to have an understanding as to how these professionals became involved with Lauren. Lauren, as it relates to Ms. Anderson and Ms. Delaney. So Lauren was having emotional outbreaks, and there were difficulties during visitation exchanges. Dad was essentially gaslighting Lauren during following visitation exchanges. The child was having some significant difficulties when she would transition from Dad's house to a Faith Family Christian, who was her daycare and preschool at the time. At that time, the child was started in counseling with Celia Delaney, who's with the tribe, and that's because that's where they received their services. So that started, if my memory serves me, the middle of January of 2023. Then there's these disclosures by Lauren. Lauren undergoes an evaluation down at Salmon Creek. They provide my client with some additional recommendations for services. Information is provided to CPS, information is provided to law enforcement, and ultimately Lauren undergoes a CJAC evaluation. And during this time, my client has followed up with a sexual assault protection order, which was granted. During that process, Ms. Day was appointed as a guardian ad litem to make some recommendations in that juncture. And we had also disclosed to the court that in the protection order that we would be filing this parenting plan and child support action in this case. So that's sort of how we started. Ms. Day's appointment then transferred over to the family law case. And as a result of the CJAC evaluation, there were no specific disclosures by Lauren at that time. It was surmised that given her age, she was 4 years old at that time, that she needed to undergo the sexual assault therapy. And there's a grant with Patricia Anderson, and CJAC referred my client to engage Lauren in the sexual assault therapy with Patricia Anderson. So that started. When the grant ran out, and if my memory serves me, that I believe the grant ran out in either August or maybe September, my client had discussed with Ms. Anderson continuing her therapy as private pay under the sexual assault therapy program, and that was approved. Lauren has made disclosures to Ms. Anderson. Lauren has made disclosures to Celia Delaney. And you'll find out that Lauren has also made disclosures to Suzanne Snow during the reunification process. Ultimately, counsel is here arguing that Ms. Rosen's reunification plan should be adopted. And the court, I'm sure, is well aware that I have a long history of working family law cases that have involved Ms. Rosen. I have great respect for Ms. Rosen. I have a long history of guardian ad litem cases with Ms. Day. And while I respect both of them, I think that they are missing the point on some of the concerns, because there are some moving parts in this process that, quite frankly, I think have been misinterpreted and manipulated in an effort, again, to deflect away from the father and his involvement involving abuse of this child. When Ms. Rosen's report was submitted, we had requested copies of the reunification counseling notes. We did not receive those until a week ago on Tuesday. I had an opportunity to finally review through those, and I did get those filed on Friday. And I think that it's important for the court to independently take a look at those reunification notes in comparison to what I perceive as Ms. Rosen glossing over Lauren's behavior or misinterpreting Lauren's behavior. And I guess from the optic, my understanding is that the person that's in the actual reunification sessions is Suzanne Snow. She's the one that's actually performing the reunification. My understanding is that Ms. Rosen is getting information secondhand from Ms. Snow. I am aware that Ms. Day had asked to be able to view a reunification session so that she could get a firsthand observation of the process, and her request was denied, even though she is the child's guardian ad litem. And I'm concerned that it was denied. There was initial pushback on my request for the reunification notes because I wanted to see from my perspective and from my client's perspective how those notes aligned with what Ms. Rosen was saying and the emotional difficulties that the child was experiencing outside of reunification, both within the school setting and within my client's household. Initially the court, when they ordered the reunification to commence, the court ordered Ms. Anderson to participate in 3 pre-reunification visits with Lauren so that Lauren could be prepared for what was happening. There was very little communication from Ms. Anderson at that time, and I wanted to make sure that she understood that if there were concerns about moving the reunification forward, that she needed to provide information to counsel and I and the court if there were concerns. And the reason why I reached out to her was because there was a disclosure that Lauren had made during the second pre-reunification visit with Patricia Anderson. And the concern was whether or not that information caused Ms. Anderson concerns about moving forward. So the pre-reunification counseling visit with Patricia Anderson, there was a follow-up counseling visit where Lauren wrote a letter to Mr. Brown. And Charlotte's report indicates that that letter, and I'll quote, "The letter appears to express a great deal of anger, fear, and frustration Lauren feels regarding her father that clearly impacts their relationship." If you look at the sealed the sealed health documents that we filed on February 20th of 2024, at pages 17 and 18, Lauren's letter specifically states, and Lauren's letter is glossed over in Ms. Rosen's report. And to be quite honest, I don't recall if Ms. Day even addressed Lauren's letters. She's actually had 2 letters, one during the reunification process and one when meeting with Ms. Anderson. Lauren stated in the letter on February 20th, "I do not like when you did that to me. Thank you. You will see what happens if you do it to me again," from Lauren. So this is the letter that she asked Ms. Snow to write so that she could talk to her dad about what was going on. It went on to say, quote, "I will scream at him if he does it again, and I will have to go to his house. I will scream so loud." Or if I have to go to his house, I will scream so loud. So this is a situation where we have a 5-year-old child who is involved with counselors who are there to protect her. She's been told that these are her safe people. And this 5-year-old is told, "You have to tell your dad this. Let's write down your letter of what you're going to tell your dad." So they're placing this child who, by all accounts, is a victim of abuse, and they're going to put her in a reunification counseling session with the person who is abusing her and tell her that she has to confront him about what he did. The optic on that is extremely concerning. Lauren had previously disclosed back in March, on March 17th of 2023, that her dad touched her private parts. On September 13, she said to Patricia Anderson that she did not want to visit her dad. On November 8th with Patricia Anderson, when my client was present, Lauren shared that she didn't want to see her dad because he makes me private and he makes me lick, and Kristen, who's his girlfriend's, private. Those are not included in Ms. Anderson's notes. Those are mandatory reportable items for a counselor. It's not up to her to determine the veracity of those statements, the source of those statements. You have a 5-year-old child who's making statements that she's not made to prior counselors that are different than what's been disclosed previously. And there's nothing, I think there's one line on Patricia Anderson's November 8th, 2023 counseling records. There was no mandatory report to CPS as a result of that. In Ms. Anderson's November 22, 23 notes, she indicates that she allowed the child to process stressors related to therapeutic visitations beginning with the father soon. And those are on page 11 of our sealed document. What that means, I mean, if you weren't directly involved, you might not know what that means. What happened is that Ms. Anderson is preparing Lauren for these visitations. And it's during this time that she's talking to Lauren about the rules of visitation, because eventually she's going to be able to set rules when she has to go to dad's house. So this suggestion that my client has somehow manipulated and imprinted with this child that she's going to have to go to dad's house, and therefore the child's fear about going to dad's house has been manipulated and promulgated by my client, is wholly without any evidence. The person who talked about this child going to dad's house was Patricia Anderson in preparing her for this whole process. On November 29th, that's when Ms. Anderson talked to me, at which time she indicated that Lauren had disclosed that her dad makes her 4 times because she's 4 years old. That is no place in her reported notes. There has been no CPS record made of those allegations by a child who is in her counseling session. And that is completely different, new information than what Lauren has previously reported. The CPS records that we just received from Ms. Day only go through June of 2023. She indicated to us that she's still waiting for the balance of the CPS records to be received, but none of the CPS records talk about, at least through June 5th, I think it was, of 2023, talk about Lauren making a disclosure that dad's required her to lower times because she's 4 years old. There was one reference about dad putting his privates in her mouth, but nothing about him, I think, putting his mouth on her private. She had talked about him touching her private. On June 6th, Lauren says to Patricia Anderson, and this is in her notes, that she doesn't want to reunify because, quote, he knows what he did. Reunification visits actually started on December 19th. And during that time, Lauren was regressing. If you look at those reunification notes, you'll see that Lauren wouldn't talk directly to Mr. Brown. She was mumbling. She was nonverbal. She pointed to Mr. Brown, nodded no to Ms. Snow, and to no avail. She wouldn't agree to Mr. Brown taking her picture. And at one point, Lauren, 5-year-old Lauren, points at her dad, mumbles the word, quote, bad, unquote, ran her own hands up and down her body, and said she was angry. On January 2nd of 2024, this is the second visit, reunification visit, Lauren remains nonverbal in her communication. She won't touch dad. She won't allow dad to touch her. January 9th, dad tries to give her a high five. She will not touch him directly. The only way that she would engage is with some object between her hand and his hand. Ms. Snow had to tell him that Lauren told Ms. Snow that she had to tell him, meaning her dad, that he's not allowed to come to her home where she moved. And that's, again, because she's already been told by Ms. Anderson that this is going to be happening. You're going to be going to dad's house. And she's trying to set boundaries for herself. She's trying to protect herself in the only way that a 5-year-old child knows how to do. Again, dad tries to give her knuckles, but she will only do that if she's touching something else. January 29th, Lauren discloses to Ms. Anderson, her therapist, who is who's to step in there if there are any concerns, where Lauren says she wants to tell her dad that she did not like what he did to her and that he knows what he did. And what he did was, quote, until they turned red. And that's on page 19 of the sealed report. The next day, Ms. Anderson's notes are dated January 30th, where it shows that there was a
let me stop you, counsel.
Sure.
Are these the ones filed on the 1st or the ones on the 20th?
So Ms. Anderson's notes are filed on February 20th, and Ms. Snow's, the reunification counselor, are filed on March 1.
And Your Honor, we had already also had objected to the court that this stuff is being filed beyond the time of a response. My client had no ability to respond to any of this or any of these statements that are being made now.
I got them. Well, we all, even Ms. Poplawski, we received these, and Ms. Day received these on Tuesday. And by the time I had it.
Well, my question is, there's only 17 pages. And you told me I'm on page 19.
That's on our sealed document that's filed on February 20th.
Okay, well, that's what I asked. I was looking, you're jumping around on me here then apparently, because
I am.
I don't know which one I'm supposed to be looking at. One's,
Okay.
so I don't know.
Page 19 of February 20th.
Okay. So you're on page
19
of that.
Which, if you're in the electronic, it's 19 at the bottom. So if you're electronically, it's probably page 20 in yours, because the first page is our cover page.
Okay, thank you.
Yes, you're welcome. So that is the January 29th note where, again, Lauren's already in reunification at this point. She's made another disclosure to Patricia Anderson. Patricia Anderson makes a report to CPS, and if you turn the page to, I think it's the next page. Page 20. Where she talks about talking to Kent Sloan, who was the intake worker, and she provides a case number. So she makes that mandatory report and then tells you what she reported to CPS as a result of that. Of course, none of that is raised as a concern about whether or not there should be a hold in reunification because the child's making disclosures during this reunification process. We didn't know that disclosure had been made at that time. If you go to the March 1, and this would be the 5th visit, which was identified, the 5th reunification visit, which is identified as January 30th. These are Ms. Snow's records, Suzanne Snow's records. Suzanne Snow tells you, or identifies in her notes, that Lauren disclosed on the way to the visitation room, quote, "Daddy licked my hearts," quote, "rubbed them," and she said, and another disclosure that she didn't hear because she was talking so quickly. And Lauren asked Ms. Snow to tell her dad. So she's trying to get an advocate to be able to tell her dad that this is what he's doing to me. Ms. Snow tells her instead that she has to share that with her father. So a 5-year-old, again, another safe counselor during this process, is telling this 5-year-old child that she has to confront with whom she's just disclosed to this counselor that he has assaulted her, and she's told at least 3 different things, only 2 of which are recorded. And if you look further, you'll see that Ms. Snow does make a report, again, to CPS. Lauren, during that process, is so angry, and you'll see, if you turn a couple of pages or scroll down a couple of pages, you'll see a page that has the word angry on it. And what that is Lauren writing angry because she's angry about this process. She's angry about what her dad has done to her. And Suzanne Snow tells you about Lauren storming out of the room. This is not a child who is having fun. This is not a child who's at ease, who's giggling. Not in one set of these visitation notes is there any reference to this child giggling or engaging in any actual touch with dad. You have this 5-year-old consistently saying, this is what's going on. She's trying to get somebody to help her. And yet you have adults who are saying, nope, the court's told us we've had to do this process. This is what we're doing. However, if you go back and look at, and again, I'm sorry, I'm going to turn you back to, I'll come up to that. I jumped ahead in my head. I'm sorry. So Lauren writes this word angry in her notes. She's storming out of the room. Lauren reiterates, again to Mr. Brown, in reference to what her dad has done to her, I didn't like.
I just want to clarify here. This is not during a reunification session that she's saying she sorted out, is my understanding.
No, it is. It's January 19th or January 30th. The January 30th visitation. This is the 5th reunification visit. Lauren writes in the process, and Suzanne Snow, if you look a couple of pages later where it says angry, Lauren wrote down talking to dad, so she's referencing the word angry.
Again, this is exactly why I objected to this. My client is telling me he didn't even have a visit on the 30th. So this is not during a reunification session.
Well, I'm looking
This child is having individual sessions as well as reunification. So the jumping around here is confusing the court as to the timeline of what's going on and when it's happening and who's present at that time. My client is saying he did not have a visit on the 30th. And again, this is why I said I was objecting to these, because my client has no ability to respond to this.
So there's obviously a lot here. And I guess I don't know, has Ms. Day seen this information?
Ms. Day has seen this. Ms. Day agrees to go with the recommendation of Ms. Rosen. And she's also requesting both parties.
Hold on. Let me hear. Ms. Day is here. She can tell me what she. Good afternoon.
Thank you, Your Honor. I did see these when they were sent out, and it is very new information. And
this is the 17 pages, well, it's maybe 16, that was March 1st.
Yes, we got them, I think, just a day or two before that, before they were filed.
Okay.
And
after she submitted her report.
After I had submitted my report. So I have had a chance to review them. I have not gone over them with a fine-tooth comb, which I had hoped to do, and still will plan to do that this week and kind of go through them. I am concerned about some of the things that I saw in there. I'm not sure that is exactly lining up in the way that reports were made or were not made. I have sent for those additional CPS records, and I shared Ms. McLean's concern. If those reports were not made, that would be concerning to me if there were new disclosures. And I agree with Ms. McLean. If a child makes a disclosure, whether it's a repeat disclosure or it doesn't sound credible, it's not my job or the therapist's job to make that determination. They're obligated under the law to report that. I did make the recommendation for the reunification counseling to continue. While I have read through this briefly, the information I have prior to getting that from talking with Ms. Rosen and reading the other information that I provided is that Lauren does make these statements, but she's not attached to the statements. It's as if she walks in and says, you know, there's a werewolf out in the front yard, and then she walks in and goes and does her thing. There's not an emotional attachment with it. It's a statement. She comes in, she makes her statement, and then she goes about doing what she's doing. So I haven't had a chance to take that part of that information that I have and this new information and see how that might impact her, if it would change what I'm recommending. So I'm standing with the recommendation. Ms. Rosen is the expert, and they are the people that we as court advocates and as professionals in the family law realm, we rely on their expertise. Ms. Rosen has been doing this for a very long time. She has all the most, the new is training and the experts involved. And I trust her when she says that she believes it's okay to move forward and that the process will allow for a better understanding of what's happening and help Lauren move through this process. That's what we have. That's where we are. And that's still my recommendation.
Well, I guess, and this is a problem coming into a case after it's been ruminating for some time with other people. I don't even know what the actual order is as far as, I've got the order.
October.
There's an order that I signed, which is not an order I made. I signed it because it was an ex parte order that came over. I believe it was 11. No, it wasn't 11-2. It might have been 11-2. Yeah, the 11-2 order. I signed that, but I was signed because it was an agreed order that came through ex parte. So I don't know the genesis of that order.
And Your Honor, that also came after the fact that every single time there has been any sort of allegation, that has completely been vetted multiple times by CPS investigations, by police investigation, lie detector tests, every single disclosure. So the judge was aware of all of this.
Let me stop you for a second. I'm trying to understand. I don't know what the current order there's no order in the file that I can find that has a specific number of visits or anything else.
Those were supposed to be determined through the reunification process. And so it was set up just to have the 1 hour to start with, as Ms. Rosen had determined what would be appropriate. Now that we've gone so far with the reunification process and what has been observed and the discussions with Ms. Anderson and with Ms. Snow, that the recommendation is to increase by 2 hours a week and to also importantly have this individual meetings with each parent because something is amiss here. And so how do we support this child? And so those were the main recommendations, as well as continuing in this therapy that Ms. Rosen has stated. And the court had already said that this child, Ms. Teethers, can continue to have this child go to the Cowlitz counseling on her own if she wants. That is fine. The court is not going to take that away. But the court independently appointed these individuals to work with the counseling and with the reunification going forward. In particular, Ms. Anderson, because she was involved with CJAC before. And so it just seems very, very interesting to me that these professionals who are highly involved in this process on a regular basis wouldn't be making reports if this in fact is what is going on. That just makes no sense at all to risk your license to be knowing all of what the rules are relative to this. And so here we have, while there were no particular amount of visits, because Judge Fassett entrusted that the experts would make the decision as to how many visits they should be in what capacity. And now they've spoken.
So to answer the court's question, if you go back to the sealed health documentation that was filed by Ms. Day on October 9th of 2023, you will see Ms. Rosen's recommendation for the Reunification Council. As a result of that, Judge Fassett entered the original reunification order that was entered on October 23 of 2023. And it's notable that at that time, Ms. Day had been requesting that Mr. Brown undergo a collateralized psychosexual evaluation. That issue has been reserved. And if you take a look at that, that's also outlined in the order that was entered both on October 23 of 23, and then the amended restraining order that Your Honor signed on November 2 of 2023 at paragraph 6B.
And
so that's currently, I'm sorry, I've given a lot of latitude. I've not even had an opportunity to finish my argument, and may I be allowed to finish?
Well, I'm trying to follow your discussion. So the order that I signed on November 2nd was, I assume, Judge Bassett's order that went through ex parte. I didn't hear that.
Correct.
Order.
That's correct, Your Honor.
So
correct.
I know nothing about that order other than my signature facilitated it getting filed.
That was Judge Fassett. That was Judge Fassett's order, yes.
Oh.
And regarding the psychosexual evaluation, Judge Fassett chose not to do that, and instead she said, no, we're going to go through the reunification. And then the guardian ad litem has not recommended that.
Okay. So I guess I'm sorry, I'm confused. It's been a long day. I haven't read this entire file. I read everything that appeared to apply to this hearing. And what I don't see is I don't see an order that says that he's got X number of visits a week or X number of hours a week, that's apparently something being determined by the reunification folks. Is that accurate?
That is correct, Your Honor. And now the
Yes,
recommendation is to increase it. Mm-hmm.
Okay.
And my client's concern is that the child has made statements and written letters to both Patricia Anderson and to Ms. Snow, asking or telling what dad has done to her and essentially trying to get them to support her request in not having contact with him. So that's why we requested these records. Again, the most recent visit that we have in the records from March 1 is from February 20th. The February 20th visit, Lauren is still disassociating. She's trying to exert control, and the way.
Okay, I read through all those, and they don't line up. I mean, when we're jumping back and we're talking about them, we're jumping back and forth, two packets of stuff. As I understand where the case sits, there's an order someplace that in some fashion says reunification counselors are going to do this process. I'm not sure why we're here, because I have a motion to follow the recommendations. Counselors, let me finish my statement before anybody jumps in, okay? Please just bite your tongue for a minute. Everybody. I'm trying to explain why I'm confused, okay? I don't have an order that says anything other than Charlotte Rosen's group is going to do this reunification. So I have a motion that says, let Charlotte Rosen's group do reunification. I don't understand that. And then I have as a response, not a motion, but I guess a response that says it all needs to stop. but I don't have a motion to that effect. So, and then we've got a whole bunch of new information here, new in the sense that it's new to the parties and apparently also to the JL. What strikes me is at this point, Ms. Day is expressing some concern, obviously, and I think everybody has concern when they see these kinds of things. But I think maybe the approach to, I'm not going to be able to make a change today because I don't know that I have information that really gives me to do that one way or the other. I think I'd like to have Ms. Day have a look at these things, investigate a little farther as to what these new information coming in, and then make some sort of recommendation once everybody said it. I mean, y'all got this on what, Friday or Thursday?
Oh, Tuesday. We got the reunification records on Tuesday.
Okay, well,
I filed them, excerpts of them on Friday.
Okay, so they're, and then I looked at them as best I could. I looked at the ones from the earlier filing because those were there last week, and then I tried to plow through these. And there's a lot of information, and obviously it's concerning because of the nature of the case and not having the background that Judge Bassett did historically as to how we got here, other than reading relatively orders that don't really tell me a lot. So I think what I'd like to do is I'd like to maybe set this out a couple of weeks and have Ms. Day follow up on this new information that came in last week, which is the stuff that was filed here on the first, 17 pages. I believe that's the notes from Ms. Snow. And then come back and so I can get a better analysis of this and see whether these are concerning or they're not concerning.
Your Honor, I think that the other piece that's missing, though, is the rest of the CPS reports from June to present. And I know Ms. Day at least indicated to me that she had made a request for those. I don't know if she's received those now or if she has an idea when she might receive those, because at least based on my concerns, if in fact Patricia Anderson has not made a mandatory report on November, whatever date that was, that's hugely concerning.
And Your Honor, I don't have a problem putting in the order that CPS, shall, maybe it'll help if there's a court order that says that they need to provide those to the GAL. I don't know, but I don't have a problem putting that in there. And I just wanted to let you know, the reason why we're here, Judge, so you don't think we're just wildly filing a motion, is after Ms. Rosen had recommended to move forward, Ms. Teeters had refused to do the extra 2 hours a week. And so that's why we had to file the motion. That's why we're here.
Okay.
Your Honor, I would add just a couple small things. The letter from Charlotte Rosen that everybody's referring to that's being followed is filed under seal on 10/9/23. I filed that, which gives kind of the outline of what to expect moving forward. So that may help with how we got here and why the order is so vague, because we were following.
And I reviewed that.
Okay, so I want to make sure.
I understand that. I just didn't have an order that sets any specifics.
Right. And we didn't have when it was to follow that plan. And then I have sent for the additional records from CPS. The records I received were from January 2023 through the first part of November 2023. So I've requested all of November to the present date, and they've responded indicating I would get them at the end of March or early April. So then we'll know if those reports were actually made or not, and that will help answer that question. CPS has been very good about, in the public disclosure part of their arm of their agency, has been very quick about getting stuff to me. So if it comes in sooner, as soon as that comes in, I will share that immediately with the parties.
Can I ask a clarifying question of Ms. Day? Yeah. So I'm sorry. So what date did you believe that the records should have run through? Because mine ended June, I think June 5.
It did end June 5 was the last report, but the search and when I received the records was at the first part of November, and they were through to that date.
Okay.
So there hadn't been any reports from June until November. We know there's at least one in November and possibly more.
Yeah.
So maybe 3 weeks would make more sense, just simply because, and part of this, I'm looking at my own calendar. I'm going to be out of town for a few days next week. So if we came back on the 19th, I'm not going to have a lot of time to go through stuff if we got it back right away. So if we put it on for the 26th, that'd give Ms. Day an opportunity to look at this, contact the parties, hopefully get information from CPS. And then I hope I make a more intelligent decision about what to do. I'm not inclined to go either direction today. These are they're concerning letters. I mean, they say a lot of concerning stuff in them. I also, and I think everybody sitting here has dealt with all the, I don't know Ms. Snow directly, but the other parties I'm familiar with, and they, you know, they've been working with this type of stuff for as long as I can remember, which is a while. And so, yeah, these are not people that I have a lot of, and these aren't fly-by-night folks that we know anything about, I guess, if that makes sense. That doesn't mean to say that they can't make mistakes too.
So my question for the court, since counsel has raised this issue, do I need to file a motion on behalf of my client outlining her request to terminate? Or are you going to consider that as a relief based on her request, based on her response?
Well, I think what I'd like to hear is once we have some more information put together by the guardian as to, I mean, probably a motion's appropriate just so it's properly before the court. It's really, we've got a motion to simply follow the recommendation, and then that this is really different than that. This is, I think, significant. This is a request to basically blow the whole thing out of the water as opposed to just do what I think the prior order seems to say. So I would say, yeah, probably.
Okay, I'll get that filed.
Okay. And if we could probably just assume we'll hear that on the 26th, and that may get bumped a little bit if Ms. Day has trouble getting records and has some other concerns, but at least that'll give us a target date.
And so, Your Honor, so how are we following Charlotte Rosen? The order was basically to work through the process with Ms. Rosen, but now Ms. Teethers isn't wanting to follow that. So how are we dealing with that now?
I think what I'm going to do, and again, this is simply because we have what I would see as concerning new information that kind of came in after everything, is essentially status quo, not increasing, but not decreasing.
So, and I guess my question is, do you think it would make sense, since Ms. Day said the end of March, first part of April, if we look at April 2?
What do you think, Ms. Day?
I think that would be fine and maybe more helpful. I can send an email to my point person who's managing this and let them know how urgent it is. And that may help speed the process up and then give me time to not only look at that information, but also process it with the other information that I have and potentially any new visit notes that come in.
I think that makes sense. Let's go to the 2nd then. So the 2nd of April, and I'll hear this motion together with any additional motions that are filed.
All right. Thank you very much, Your Honor.
Thank you, Your Honor.
All right. So do we have the Olsons? Mr. Olson, do we have Tiffany Olson there? Okay. And I know my investigator, Ms. Schaefer, is, excuse me, on the screen right there. So did you folks receive a copy of Ms. Schaefer's report?
Yes, I did.
Did you receive that, sir?
I did.
Okay. So this is essentially a continuation of a trial that we heard some time ago. Looks like we did that on February 1st, about 2 months ago, a month and a half ago. And it appointed Ms. Schaefer to look into this and receive the report. And so let me just get myself back up to speed here. We did not do, so I guess you two tell me what your feeling is about this recommendation, which just in summary, provides a little different approach than just the modification that we were here about. So,
You want me to start?
yeah, I think, yeah.
I feel like this would be a step forward. I don't know how you would go about the UAs. It seems that he stated at our last court date that he was clean since July, and that's clearly not the case. So I think that this, if he has a certain amount of time, being able to get a certain amount of visits back would maybe give him some motivation to stay clean so that he could spend some more one-on-one time with Zach.
Let me see here just a second. You're still working through the methadone program?
Yes.
Okay. How's that going?
It's going fine. I kind of actually like stepped it up and requested one-on-ones, not on the phone, but at the facility with my counselor, and to try to get more involved.
Good. So, Ms. Schaefer, did you have any comments about your report that might be helpful as far as your recommendations at this juncture?
Clarify that when Mr. Olson starts earning that.
Not hearing you very well. You might not have the mic real close.
Can you hear me now?
Sort of.
How about now?
There we go. That helps a bunch.
I just wanted to clarify that when Mr. Olson starts working towards earning that time back, that I hope that his mother is still open to allowing Zachary to go there for the whole weekend so that he's still in his dad's presence, but his dad will then start earning those rights back. It wasn't real clear in my report. Mr. Olson does seem to be making the right steps to getting clean, and it does seem that Zachary is a good motivation for him. I just worry that I don't want Zachary to be the only motivation for him.
Do you have any, assuming he's continuing in the program, which is essentially it's an MAT type program with the methadone, as long as he's in compliance with that program, do you see that as a barrier?
I don't see that being a barrier, no, especially if he continues to do his mental health counseling separately in conjunction with that through Core Health.
It's the other stuff that was in there that makes me nervous. So, okay.
And then I think Ms. Johnson also had a concern, and I really didn't follow up on this. I did have a hard time getting some answers from Mr. Olson. She was also concerned whether or not he had legitimate and legal driver's license and insurance. But I don't believe that Mr. Olson is transporting the son at this time. So, and that can change at any given moment as well. But I do know that was a concern for her also that she would like to address.
You have a driver's license?
Yes, I do.
And car insurance?
Yes, I do.
And do you have that with you?
I've got my driver's license with me. Okay. Would you like to see it?
You want to take a look at his driver's license? Or?
No, I mean, he's not going to transport right now anyways. It was a concern because if he's unable to pay his regular bills, then I thought maybe insurance might be put on the back burner. And I just want to make sure that Zach is transported, by Kay or us. So that.
Good afternoon, ma'am. How are you today?
Good.
So when you were here the last time, I asked you if you were willing to continue doing what you're doing for a while. Are you still in a place to do that? That's an imposition on you, obviously, and the only way it's going to work and make everybody feel comfortable with this is if you're still willing to do that.
No problem. He's been in my life 14 years of his.
Okay. Well, when I look at this is I guess what you'd call this kind of a step type of program, which requires you to do the stuff you're supposed to do, provide the UAs as requested. And again, I think as long as you're enrolled in the methadone program and you can provide, say, a monthly report that you're in full compliance there. There's a lot of folks that, they work regular jobs, they're out in the community that are on methadone. That's been around since the 60s when people came back from Vietnam. Methadone can be a problem, but if it's that's a monitored program, as long as that's the only thing showing up and that he's in compliance with his treatment there, that's not a huge concern for me. They may place limits on you driving with that. I don't know. Typically not, but they could. So you need to make sure you're in compliance with that. But so when was the last clean UA we had other than the methadone? Do we have that?
In her results, it says that 221, it says that he's failed all December, January, and 221 tested positive for fentanyl.
Okay.
Your Honor, the last report was, I think, in November that he had a clean UA. And then according to Mr. Olson, when he learned that he wasn't going to get visitation, he unfortunately went the wrong route and had a slip up. And it just seems like he's had a hard time getting back to that right mentality.
So as of right now, we don't have a clean UA?
No, not at this time. I have not seen one.
Okay. If you took a UA today, would it be clean, sir?
I don't know how long that fentanyl stays in your system, and the last one that I had that had come up positive, I was really surprised that it would. I think I would come up clean today.
So Well, this recommendation would be about a month and a half after you provide a clean UA. That would be nothing but methadone, so long as you're in compliance over there, before you could start progressing through here. It seems like a pretty solid recommendation, frankly. It's gonna provide you with at least some comfort that he's not using other stuff. Methadone, if it's not being abused, again, it's a maintenance kind of drug. It's almost, I mean, it's like I said, there's a lot of people working fairly high level jobs that take methadone on a regular basis. Unfortunately, that seems to be one of the treatment methods that we use, but it is there. So,
Your Honor, I don't plan on staying on that. I plan on weaning off that as soon as I can, actually.
good. Well, and so you may want to talk with your doctor. There's a few other things. There's a drug called, I believe it's called Vivitrol, which is a non-narcotic type of drug that helps eliminate some of those cravings. It's an expensive drug, which is one of the problems with it. So depending on what your resources are or what insurances you may have available, I don't know, it may be better than it used to be, but that's another option. So you may want to talk to somebody about that.
Okay.
It's a blocker that takes away your craving. So methadone essentially is a replacement drug. So you're still getting a feed from that. So, but we got to get all the other stuff out of there.
Okay. We're going to be,
okay. So in the meantime, I don't know if we want to just set another review out of ways and see how this is going.
I would, yeah,
Does that
I
work?
would be in agreement to that at the
Okay.
45 days or month and a half or,
Okay.
and with a clean UA and move forward.
So why don't we do this? I can just do another order that essentially adopts these recommendations going forward. We both got a copy of them, and I could set a hearing, let's see here. I need to check and see. I'm going to be out of the area a few times coming up, so I got to make sure it's a date that I'm here. If we were to go the 16th of April, does that work for both of you?
Yeah.
And I would just put it on this docket, so we just put another review out, and I can do an order that adopts this recommendation.
1 p.m.
1 p.m. And I put you on the end of the docket in part because I didn't know how much more we had to do on this. So I didn't want to try and do a trial if we had to do any more work on that. But if we set a review, I'll try and get you guys in and out real quick if things are going well.
Hey, can I
So-
ask 2 more questions?
Yes, ma'am.
Will that just be 1 test, 1 UA for that day, or is
No, I'd
there a
want
way to know that he's been clean for those 45 days?
If we think are you taking regular UAs with your treatment?
yeah.
Okay.
But
How often?
they're just kind of random. It seems like I should be getting a little bit more, honestly. It seems like I only get like 1 every 2 weeks, it seems like.
Okay. That's not abnormal for treatment programs.
I'm
So
wondering if I could maybe ask them if I could get at least 1 a week, or, because I've talked to my counselor about what's going on right now,
if
and
they're able to do that and then get a copy to you as well as to the court, that would be helpful.
yeah, okay, yeah,
So, I mean, really the goal here is to get you clean so you can be part of your kid's life.
absolutely.
And-
Thank you.
And I'm glad that you're participating. That's a good program over there. So, so we should have 2 or 3 UAs over the next few weeks, and 45 days means if you got 1 dirty one, we start the clock over.
Gotcha.
So,
Not gonna happen.
okay, good.
And then I had one more question
Yes.
regarding spring break. The current parenting plan says Thursday through Thursday, and that was based on a Monday through Thursday school schedule.
Mhm.
So it's just, Kate, or they have Zach, the 22nd, 23rd, and 24th, and that's the week of spring break.
Okay.
If we could just transfer on Wednesday so that you guys could have them additional, would that be okay?
Yeah.
You'd have them half the week and then
Yeah.
I'd have him the other half. I just want to make sure it was.
Well, here's the thing. If the 2 of you come to an agreement, or the 3 of you, that you want to adjust something for a particular day or a week or something something's coming up and you want to work around something, you're free to do that. Don't feel that you're not getting in trouble with me if you come up with an agreement. We're going to do something different this week because,
Okay.
botany day or something.
Okay.
'Cause I was,
So, yeah, you're not going to get in trouble here as long as you're doing it by agreement.
okay.
So however you handle spring break is fine with me as long as you're both comfortable with it.
All right.
Okay.
I am
Thank you.
questioning the transportation. I'm feeling a little guilty that that they're having to do all the transfer.
As long
Well-
as Zach's safe, that's what.
Once we get you clean
Okay.
and we get you past this, but 45 days out, we'll take a look at it. I think you should be doing some of that too, obviously, but let's get you to the place where everybody's comfortable with that.
Okay.
So, all right, so we will see you, what did I say, April
16th.
April 16th. All right, we'll see you then. Keep up the good work at the treatment. That's very important.